Lamar Centre.
No. No.
But an EA link. This looks like random. Lots of bands.
Good morning, everyone. It's 9:30 and the inquiry is resumed. Hope you can all hear and see me okay, but let me know if not. Good, thank you. So just a reminder, this inquiry relates to the appeal made against the decision of Charnwood Borough Council to refuse an application for development at land to the east of Cossington Road, Sileby. The proposal is for up to 170 dwellings. This is the second day of the inquiry and a few housekeeping matters as normal. Please ensure mobile phones and other devices not in use for this event to switch to silent, please. Unless you're speaking, please switch off your microphone and video, and unless you're one of the barristers. The first session we will run up until about 11 o'clock today, followed by a break of about 30 minutes. The second session will run until about 1 o'clock, followed by an hour's lunch break. And the third session, should we need it today, will run from 2 till 3:30 p.m. So on Monday, day one of the inquiry, I heard from interested parties and held question and answer sessions on highways, flood risk and ecology matters. Today, the intention is to hold a roundtable discussion on education matters before holding a roundtable discussion on conditions and obligations. Before we go to the first of those roundtable discussions, just some procedural points. I've circulated an amended programme, which I see the council have put online, thank you, which hopefully covers everything in light of the changes needed based on witness availability. So just to confirm, we'll be sitting today and then this Friday, the 25th of April, to hear Mr Higson's evidence. Then on the 4th of April, we'll hear from Mr Cook. And then on the 27th to the 29th of April, we'll hear from the two planning witnesses and closing submissions from the parties. I've gone for that now. That works best for me. Are we all happy with the programme as amended, Mr Tucker?
Yes, sir.
And Mr Richards?
Yes, sir. Thank you very much.
Okay, thank you. Well, hopefully, I hope Mr Cook is doing okay, Mr Tucker, and hopefully we'll.
Yeah, he's not made the miraculous recovery that I had overly optimistically hoped, but he still hopes to be in a position that he will be okay enough to listen in on Friday, or at worst to watch the YouTube video in advance of the 4th of April.
Okay.
So as ever, we wish him well for a speedy recovery, sir.
Absolutely. Okay. Thank you, Mr Tucker. Okay, so just a few things on documents. I've been provided with a map of housing sites around Sileby. I note that doesn't include the site for 50 odd houses at the bottom end of Cossington. I think I see the email, Mr Richards. I think there'll be another map to come.
Yes, it's. I mean, it's a field southwest of Cossington.
Right.
West of Main Street, north of Sileby Road.
Siston Road, is that?
So yeah.
Siston.
Sorry, Siston Road. Yeah, sorry.
Yeah, it's okay.
Yeah. But we'll provide you with an update, and then I think it's tolerably clear. You'll have that map. You'll have the emerging local plan policies map, which is CD 6.05.
Yeah.
And you'll notice a remarkable degree of similarity between the two.
Okay. I also noticed that I think it's been added fairly recently. There's the pre-submission plan of the Cossington neighbourhood plan, which I spotted and had a look at, I think, on Monday afternoon. And I think that has an allocation within it, but I don't know if that's the same as the field to the southwest. But I'll wait to see the map, and we can always clarify that.
Yeah.
Thank you. If that map of the Sileby sites can be added as inquiry document 4, please, and if the council can create a sort of inquiry document list on the webpage, please, for all the inquiry documents that have been submitted so far. I think that's best approach, rather than creating new core documents, which don't always get picked up as easily. I think if they can be added as a separate inquiry document list, and let me know if there's any query on numbering. I'll leave that with you, Mr. Richards, and the council.
Yes, sir.
So, thank you.
People are listening. I'm confident.
Fine, thank you. I assume that's all okay. And then I've had an updated Section 106 agreement that's dated the 18th of March. It came through yesterday. It shows the track changes version and a clean version of the 106, which I've gone through. So thank you for that, as well as a map showing the extent of the land that's covered by the 106. So thank you for that. If we add that email as, or rather, I don't think we need to add all of it. If we just add the clean version of the 106 as inquiry document 5, rather than overwhelming the number of inquiry documents, if we just say ID 5 is the clean version of the 106 dated the 18th of March, then that's on record. Thank you.
So could I just mention, in terms of the amendments, the principal amendment in relation to that relates to ensuring consistency with the council's SIL compliance statement and what's in the 106 obligation. I think there was a hangover from a previous approach by the authority, and that's been tidied up now.
Okay, well, we'll no doubt discuss that later on today when we come to that session.
Yes, yeah. So when we'll be joined by Mr. Wakefield, who'll talk about that from the appellant side. Okay, thank you. Great. Then I think that's it in terms of outstanding. Well, actually, no, I haven't seen any update on conditions, unless I've missed something. I don't know if there has been anything sent through. It was additional conditions or any amendments to conditions that I was looking for. I don't know if Mr. Richards knows.
Well, I've seen a document just this morning.
Right.
Which I gather was floating between the planning witnesses yesterday. But I think it would probably help if you saw that. If that could be sent to you while you're doing education, then no doubt we can all have the same sheet on our screens when we come to conditions.
Yes, I think that would be helpful. Mr. Tucker, I assume you've seen something similar.
Yesterday, sir, it was my understanding was it had been agreed by Mr. Gould yesterday, and I apprehended that it was to be sent to you yesterday also, so I don't quite know why it's only got to my learned friend this morning and you not at all, but we'll make sure that's resolved now. In fact, I've just had a message from Ms. Smedley to say it's being sent to PINS immediately, so okay. Not sure what the ghost was in the machine that caused that, sir, but it should be with you before the condition session.
That's fine. I think as long as I've got it before then, that's fine. We'll certainly have an adjournment before then, so there'll be time for me to go through it, hopefully. So thank you. Thank you. So I don't think there are any other outstanding documents or outstanding points. Richards? Yeah,
just one thing. So you asked us to confirm whether or not we wanted you to go on the train.
Oh yes.
But the answer is we do.
Right.
And what's more, we've got the train line website timetable for you.
Excellent.
You've got a choice. You can either go south to north and then have about an hour wait in Sileby to look at anything you wanted to in Sileby before catching the train back south again.
Okay.
Or you can do it the other way around and have a 20-minute turnaround time.
Okay.
So we'll provide that information for you with the timetable, and you can work out what is most convenient for you to do.
That would be helpful. I think I was trying to look at the timings and work out exactly how it might best make best use of time without having to hang around too long. Although if I time it right, I suppose it can always be over a lunch break or something. But it's yes, it was just it'd be helpful to have that timing options. I assume, Mr. Tucker, you have no objections to me going on the train?
Completely no objection to going on the train, microlight or any other means of transport, sir. My only thought in relation to the train, and obviously I can't speak to Mr. Cook in relation to it, so this is very much my thought, is that if you are going to go on the train trip to have a look at the site, you need to see it in both directions for obvious reasons. So the logistics of that may be a little more complicated. So no difficulty. In fact, we would welcome it. But if you're going to do it, you need to see it in both directions to get the proper picture.
Yeah, no, absolutely agree with that.
Okay, well, hopefully the train times will work out, and I can sort it out. I think what I would envisage doing that after the site visit on Tuesday. So once I've finished walking around with the parties, I would then do the train probably. But I'll check what the timings look like, and we can confirm that nearer the time.
Thank you, sir.
Thank you both. And then just one final question to ask: are there any interested parties who wish to speak today who haven't already indicated that they wish to speak? There are obviously opportunities to speak today during the roundtable discussions, but if there's anybody who wishes to address the inquiry and hasn't done so already, please let me know. But if there isn't anyone, that's fine. We'll move on then to the roundtable, unless there's anything else from anyone.
So shall I? I'll be here watching, but I'll turn off because you're primarily interested in the appellates and the county council.
Yes. So yes, that's fine. If you, certainly be around just in case, Mr. Richards. But I'm obviously not expecting the borough council to be playing an active role in this.
No, I'll just declutter your screen by removing myself.
Okay, thank you. So, Mr. Tucker, from the appellant side, we presume you'll be present along with Mr. Hunter.
It will be myself and Mr. Hunter, but primarily Mr. Hunter.
Okay, yeah, I can see Mr. Hunter is in the call. And then from the county council, I can see Mr. Thomas is here. Hi, Mr. Thomas.
Good morning, sir.
And is your colleague here, Mr. Townsend, as well?
Yes, so we've got Sharon Townsend, who's our school place planning officer at the county council. Also with us today, we have the head of service, David Atterbury. We're not necessarily expecting David to answer any questions other than if something arises that Sharon is unable to deal with, particularly around early years, and if anything comes up around transportation matters, then David's available to answer.
Okay, thank you. That's helpful. Okay, so I circulated yesterday afternoon an agenda. I hope everyone's seen that. Mr. Thomas, did you see that? I appreciate that may have come to you secondhand.
I did see it. Thank you.
Yeah. Okay. So hopefully everyone's happy with the agenda and how it's set out. And I've just seen Mr. Hunter and Ms. Townsend both on screen now. So hello to both of you.
Good morning, sir.
And I set out in that document, that agenda rather, some key documents that we were going to rely on. So hopefully that they were the most obvious ones, but obviously includes appendices to proofs and statements. But do let me know if there's anything else you want me to have to hand. But I've got all of those documents to hand, so hopefully that will cover the main elements. Just to sort of make people aware, this is a roundtable discussion, so there's no formal presentation of cases and there's no cross-examination. Comments and questions should be directed through me. So during the discussion, I'll invite contributions from one side and then the other. Any interested persons listening who want to make a point, then please let me know. And if you feel I'm moving on before you've had your say, just let me know. That the raise hand function is probably one of the easiest ways of doing that on Teams, but hopefully we'll make sure everyone has had their say. So that's all I want to say by way of introduction and documents. So if we then turn to agreed matters that have been agreed and disagreed, we have the statement of common ground between the parties. Thank you for that, which sets out agreement on sort of the relevant planning policies and NPPF and the County Council's planning obligations policy, and also relevant guidance in terms of the Department for Education. I also note there's agreement on pupil yield from this development. There's no dispute over that, and there's agreement on the cost per pupil place figures. So there's no argument over that. There's also agreement on catchment areas for each education level, or where the catchment schools would be, and there's no dispute over the ultimate figures that are being sought. Obviously, the disagreement as to whether or not those contributions should be sought at all, but the sort of broad figures are are agreed, and obviously they will depend on ultimately on the number of houses built in due course. So that's the overall figure may change. I assume that's all kind of agreed, and nobody wants to deviate from that. There's also agreement that Mr. Hunter's proof is based on information that has been superseded by more recent analysis submitted to the County Council. I just wanted to check on that point, because obviously that will potentially have a bearing on our discussions. Is that correct, Mr. Hunter? That your evidence is obviously not based on the most recent analysis?
So that refers to the school capacity submissions. Now, in 2019, Leicestershire submitted their school capacity figures, which went to the Department for Education for analysis and approval. They were then published in the public domain in March of 2020. Subsequently, the 2020 projections were cancelled by the Department for Education due to COVID and to take the pressure off the education authorities. So there were no projections produced in March of 2021. The most recent projections are actually published by the department, by the DFE tomorrow. Unfortunately, just before this inquiry was underway. So the most up-to-date verified figures in the public domain are the projections utilised in the education report. But it shouldn't actually make a difference, because I don't think that we're going to be referring specifically to those projections throughout this. We're going to mainly be discussing the evidence produced by Leicestershire County Council.
Okay, thank you, Mr. Hunter. Mr. Thomas or Ms. Townsend, anything you want to say about the sort of the evidence and the figures in response?
I was going to invite Sharon Townsend just to comment on the figures, the data, to see whether she agrees with those comments.
Certainly, from what Mr. Hunter said, they did a SCAP return in 2019, but we did sorry, it's okay.
It's like echo, isn't it?
Yeah, sorry, apologies, it's echoing my side. But we also did a SCAP return in 2021, which will be published.
Is that the one that's due to be published imminently?
It is, yes.
Okay. And are those figures what you've been basing the council's response?
Yes,
on?
obviously our data will be more up to date than the ones that Mr. Hunter's had the opportunity to access.
Okay.
As discussed, though, sir, the actual figures that we will be discussing and that are from the Leicestershire County Council's responses. So we're going to be dealing directly with those to ensure the most up-to-date information is
okay. I suppose what I've been understanding is if the published data that comes out in the next day or so changes things dramatically, is that something that would need to be brought to my attention? Did the parties anticipate that needing to be sort of further information provided? Mr. Hunter, first of all.
I would actually say no, that's very unlikely. The 2019 SCAP projections actually over forecast the number of pupils that were expected to be in Sileby primary schools in the 2020-2021 academic year. So if anything, the projections should actually be lower to reflect the current figures. So I don't think that it's likely to make any difference, but I can certainly review and if it does, following publication, come back to you on that. That's not a problem.
Okay, and Ms. Townsend, any comments?
I think the main difference is there's been a significant amount of housing applications granted permission last year.
Right. Okay.
And the second, the capacity of the schools. But obviously we'll get onto that, won't we? As we go through.
We will come to that. Yeah. We're still getting sort of echo on your line, Ms. Townsend. I don't know if there's any way.
Yeah, it's really echoing on my side. Let me change that.
Have you just got one device working?
So it may be we're in the same room, so I'll try and connect some headphones. So just bear with me for a moment.
Yeah, that probably is the thing. If you're in the same room, it's probably picking up.
Is that better?
That sounds better. Yes. Mr.
Lovely.
Thompson has got his microphone muted anyway, so that automatically has made it better, I think. Okay. What I will say then is, thank you for that discussion on figures and so on. We'll see how the discussion goes this morning, but it may be helpful for the parties to perhaps clarify their differences on figures, perhaps in an addendum note after this discussion. But I think we'll keep that under review and see whether there's any further sort of addendum or anything else that could be submitted to help me understand the parties' positions. That's what I wanted to say in terms of item 2, in terms of matters that are agreed or disagreed, unless there's anything else or any updates from anyone. If not, then I'll put on the agenda item 3 about policy and guidance. Obviously, both parties have drawn my attention to national and local policy and guidance. So I'm assuming I've got in front of me everything that I need to have reference to. I think the planning obligations policy document from the County Council may well be needed in terms of referring to that, along with the DFE guidance and NPPF 2. The planning policy guidance, I think the appellants raised that, Mr. Tucker raised it on Monday as sort of being relevant. Is that something anything you want to raise now, Mr. Tucker or Mr. Hunter, or come to it in due course?
So its implications we probably want to come to in due course. In terms of what it is, the relevant part is obviously the obligations section, which expands upon paragraph 38 of NPPF and sets out in the obligations section at paragraph 008 of that chapter, which is chapter 23B of the helpfully labelled PPG, that what decision makers should do, together with paragraph 004 of the PPG. And so it's obviously mitigating the impact of development. So it's not a means by which one can seek contributions because it's fair or because it's thought appropriate or it's proportionate. It's mitigating the impact of development. That's paragraph 004. And paragraph 008 tells us that plans should set out the contributions expected for the development. That's a point that's so good that it's made a number of times and repeatedly in the section. It also talks about the fact that any contributions sought in policy need to be viability tested. You can explore in due course whether there's any such evidence before you in relation to that, as whether that's been done here and examined. And now you note, sir, that it's in an obligations guidance document, not in a DPD, but that's a matter that we can come to in due course as well. And perhaps most importantly in this context, given that capacity seems to be one of the issues, you'll note that there's tucked away in the authority's response to your questions, the reference to the word net capacity rather than capacity. The capacity is what is required, school capacity, and that's paragraph 008. There is a bit of a two-step done by LEAs to use a net capacity, and there are various policy decisions taken by different LEAs because there is no national guidance as to how you deal with net capacity. Relies upon national audit offices in different appeal decisions you might have seen, which have nothing to do with planning policy. But so the test is that decision makers should consider existing or planned / committed school capacity, full stop, not net capacity. And
So
whether
is that paragraph 008?
008, second substantive paragraph.
Okay. Thank you. Anything the County Council wants to say on the PPG or?
So just to say that obviously we've had regard to the planning practice guidance and also the NPPF, which is obviously relevant as well in the comments that we make. And I don't have a specific comment about the net capacity point, and I think we'll probably come on to that in a little while. But certainly the guidance that within those relevant paragraphs that Mr. Tucker's just referred to has been taken into consideration, and we believe that the response we've provided is robust having regard to that.
Okay, thank you. Anything else to add on policy or guidance?
Yes, sir. Just to be clear, it's not a matter of having regard in relation to this. This is the only place where you have any national guidance which is specifically directed towards planning decision making, and there is no warrant, and you'll be aware of any number of appeal decisions, sir, where there are attempts to try and knock down what is meant by the word capacity. There's been no attempt to substantiate why you should do that in this case by this authority. If there was, then we could dip our toes into some of the areas that other inspectors have grappled with. But all you've got is simply the assertion that you should be looking at net capacity, not capacity. Well, the guidance is clear. You need to look at existing ... capacity. Full stop.
Okay. Anything else anyone wants to say? Are we happy to come to this point when we discuss the details? Yeah, well, happy to move on. Thank you. Well, I say obviously policy and guidance, we can come back to refer to as we go. Thank you for that, though. The item 4 then, obviously, we'll spend the most amount of the remaining session on about the disputed education contributions. So I've set out a number of bullet points. Just by way of introduction, and just to sort of set a little bit of context, I'm aware of the appellant's heads of term letter that was dated, I think, 27th or 31st August 2021, that indicates agreement to early years and primary school contributions, and then says possibly could provide up to a certain amount of secondary and special educational need contributions depending on applications being determined. A note from Mr. Hunter's rebuttal that he says that things have moved on, that the appellants have assessed this in more detail. But I suppose if you wanted to briefly elaborate, Mr. Hunter, what you mean by that.
Certainly, sir. Just to sort of give some background from my perspective, I was instructed by the appellant in January of 2022 to review the need for education and also healthcare planning obligations, specifically against the tests of SIL Regulation 122, to ensure that they were necessary, directly related, and fairly and reasonably related in scale and kind. So the work undertaken to assess the appropriateness of the planning obligations was included as the initial proof, which is CD 10.23, dated the 28th of February. In terms of my involvement, there's been many different responses. We have the original response from the County Council dated April, which was
of last year, presumably.
Of April of last year, thank you, yes. So that is CD 4.12 and CD 4.13. Subsequently, they then updated that consultation response, which is CD 4.28 in December. That added the additional element of secondary school provision planning obligations, which weren't included in the original consultation response. And following that, and it's mainly through the analysis of Leicestershire County Council's responses with regards to this planning appeal specifically, and I think what I will be referring to predominantly is the planning obligation position statement, CD 8.11, which, as I will demonstrate, really does undermine the need for planning obligations and really does bring into question whether the burden of proof that harm would arise should planning obligations not be provided. So and because that document was dated 7th of March, then it is really in response to specifically to Leicestershire's evidence that any previous agreements were called into question, and this ruling was required.
Okay, so it's not. So it's basically essentially an updated updated position based on your analysis, Mr. Hunter.
That's exactly right. Yes.
And just to understand, the heads of term letter did say about agreeing to contributions dependent on other applications being approved. Are you able to comment on why that was set out in that letter or not?
I believe that, yes, the reason that would have been set out is because in the evidence provided by Leicestershire County Council, they have included a number of developments that have yet to receive a positive determination. As such, it wasn't guaranteed that any of the schools that they were referring to will actually be going over capacity. We will certainly be getting into the figures provided by Leicestershire. There has been, as we will demonstrate, quite a significant deviation in figures provided and the evidence to substantiate those figures, which we'll happily discuss further.
Okay, thank you. And just one, right now, I've asked if anything the County Council want to say in regards to that letter and Mr. Hunter's response. Anything from Mr. Thomas or Ms. Townsend? No.
Nothing, I think, from either of them at the moment, sir.
Okay.
Beg your pardon.
That's okay. That's fine. I just wanted to sort of set the context with that letter. I think one final thing I just wanted to check with Mr. Hunter. The viability may come up later in discussion, but you make reference to viability issues in your rebuttal about education contributions potentially having viability issues. Do you make that in a general sense rather than specifically to this case?
Yes, sir. That's very much in a general sense. It's more to demonstrate a sort of wider issue that if planning obligations for education are not secured, that it should not be a reason for refusal on its own, because there is always a mechanism available for the county council to be able to fund additional school places should they need to, which is via their basic need. Basic need is calculated on the basis of the number of places required for the area, and then discounted off that figure is any secured Section 106 or SIL related planning obligations, just to ensure that there is no double counting. So the point was more a sort of wider general point on the importance of education planning obligations and how in, for example, zero rated SIL areas or developments with severe viability issues, they can't always provide those planning obligations even when they're requested by the county council. However, that shouldn't be a reason for refusal because there is always a mechanism to be able to deliver those places anyway.
Okay.
So it was a wider sort of more general.
Yeah, you weren't arguing that there was viability issues with this scheme.
No, sir.
No. Okay, I didn't think that was the case, but just wanted to clarify. Thank you. Anything the county council wants to say in response on that, Mr. Thomas?
So just in relation to viability, I just confirm that is our agreement, our position as well. We're not aware of any viability issues specific to this scheme, and we haven't seen any viability appraisal that's been submitted as part of the planning application or since then. So as far as we're concerned, the scheme is viable and can afford the contributions that's been requested by the county council.
Okay.
And yes, please, sir. In terms of the comment on the basic need, what Mr. Hunter is implying is really that instead of passing that viability to the local authority, to pass it to central government. When we do our data returns, we deduct the numbers of Section 106 places that are funded. So to suggest that the developer could have their houses built at the expense of central government rather than local government from the basic need isn't really a positive thing to say, is it?
Thank you, sir. Yes, if I may, it was the point on viability was more of a sort of wider point about the about planning obligations, whereas, and we're certainly not talking about viability with regards to this development. What is very clear here is we are discussing whether the planning obligations are SIL Reg 122 compliant, whether they fulfil the tests, and whether there is sufficient existing capacity in the system to be able to accommodate those pupils. And very much, sir, the burden of proof is on Leicestershire County Council to demonstrate that there is going to be a deficit and that those places cannot be accommodated within the existing school system. And that's what we're going to be focusing on today.
Okay. Thank you. Mr. Tucker, you have your hand raised.
I do, sir, and a mouse that doesn't work. Yes, sir, the reason for that was really just to respond to what Ms Townsend has to say, which is the generality of the position, which I read out from the PPG, which is not us that's saying about viability having to be the foundation of policies in relation to obligations for education and other public infrastructure. That's what the government is saying within the PPG. It's also what the government is saying within the MPPF. And so just to correct a reference I gave you, I made reference to paragraph 38 before. I of course meant paragraph 34, which talks about the fact that plans should contain policies in relation to the provision for contributions for education. And as you'll be aware, sir, plans and the policies within plans are viability tested as a matter of requirement from national policy in any event. So it's also underscoring exactly the same point. So I'm afraid that the slight sideswipe that was given is ill-directed. It should be directed towards government, not towards my client. But to be clear, we're absolutely not saying that this scheme is not able to afford this, but that's not a matter that's between us. The issue is whether or not the contributions are justified within the terms of SIL Reg 122. That's what the County Council's policy says.
Okay. Anything else to say on viability? I'm pretty sure we may have gone down a slight rabbit hole with that, but if there's nothing else to say on that general point, then if we dive into the specific contributions, and starting first of all with the primary education contribution. So this is obviously seeking a sum of money towards primary education in the local area, and this would, I think the 106 refers to it being to go towards Redlands school or another school in the local area, and I suppose what I need, this is probably the one where we'll spend the most amount of time, I would imagine, understanding the sort of position in terms of the places. There's obviously 3 schools within the local area. I think Redlands being the catchment school for admissions purposes. I suppose, Mr. Thomas or Ms. Townsend, first of all, I think I'm still struggling slightly to understand how the County Council can say that Redlands would have a surplus of 28 places if the development goes ahead, when the 2 other schools are projected to have deficits. And appreciate 28 places. That's 28 places with this development, and presumably all the other known approved developments as well. Is that correct, Mr. Thomas or Ms. Townsend?
Yes, that is correct. Yes.
Okay. So why is it? So why is it worded that way? It's to say that there's a surplus of 28 places.
Because when we do our assessments, we do it across the net capacity of the school. We take it on the 2 and 4 year average of the things, and then we add in the housing gain. So when we've done, sorry, I'm echoing again, David. When we go through that, we look at the 3 schools within the 2 mile radius. And whilst the encatchment does have 28 surplus places at this point in time, overall they will be in a deficit. Now that is because of housing gain that's already been granted planning permission. That 28, of course, will take is an overall. It won't take into account the different year groups. So to offset that, and popular parental choice, whilst there is that surplus at that current school, overall in the area there is a deficit of 94 places.
Okay, we maybe come to that deficit point in a moment. But so in reality, would there be 28 spare places at Redlands in the future if this and other developments go ahead?
At the point in time when this forecast has been done, yes.
Okay, but the pupils generated from this development wouldn't be
It's
necessarily. This is 51, yes.
Yes.
But that figure of 28 assumes that 51 is absorbed somewhere into the school system. That there would be 28 places even once you've taken into account the 51 pupil places that this scheme would generate. Have I understood that correctly?
No, sorry, excuse me. There are currently, we've got 100, after we've taken on the section 106s that have been funded, we have an overall deficit of 94 places in that area. So that will include the 51 places. So there'll be 51 yielded from that will make part of that deficit, even though there'll be.
Okay, even though there'll be 28 spare places at
yes.
Redlands, which is the catchment school.
Yes, but overall, because obviously some of the other schools are oversubscribed, so that's why they've come to that.
So somebody moving into this development and with a child of a primary school age, why would they not be going to filling one of those spare places at Redlands?
Because parental choice, they may choose to go to that school, or they may not. Historically, a lot of children that go to Redlands actually go to Cossington.
And I assume that's presumably because it's nearer, or the
could be siblings, could be any kind of parental preference. There's a lot of people move into rented accommodation and move out. There's lots of movement.
And that's presumably based on data for where people live at the moment and where they send their child.
Yes.
The people on the southern edge of Sileby more.
Potentially, it might be more convenient on their route to work. Parental choices, they might like a smaller school.
Yeah.
There's, as I say, the significant housing in the area, so people are moving in all the time. It isn't this is a snapshot in time, obviously, when we do our responses.
Okay. Fine. Anything that Mr. Hunter wants to say about the surplus issue before perhaps we look at the overall deficit?
Yes, please. Ultimately, this is the fundamental issue of which we are simply not in agreement here from a primary school infrastructure perspective, and then certainly from a school transport perspective. I think that everything that Ms. Townsend has just said with regards to spare capacity in the system has indicated that the catchment area school will not be oversubscribed and will have surplus places following the positive determination of this development. If I may, I'd like to just direct you specifically to Leicestershire County Council's policy document, which is CD 6.33.
This is the planning obligations policy.
It is, sir. Yes. So paragraph 42 of their policy, it states the capacity of the catchment school in terms of primary provision and the nearest school in terms of secondary provision will be assessed.
So just pause there, Mr. Hunter. Do you have that, sir?
Yes, I do. Sorry, it's okay.
Yes.
Is it on page 21?
Yes, paragraph 42. So it lists
methodology.
Yes, thank you.
Okay.
So it states where a new development is proposed in an area with sufficient projected capacity, no financial contribution will be required. So that's paragraph 10 of CD 6.33.
Yes.
So where a new development is proposed in an area with sufficient projected capacity, no financial contribution will be required. And the fundamental issue is that in the planning obligation statement at CD 8.11 and confirmed today, this site falls within the catchment area of Sileby Redlands Community Primary School. The school has a net capacity of 420 and 392 pupils are projected on the roll should this development proceed. And simply, sir, on that basis, there is no there is no reason for planning obligations, and it cannot be said that harm would arise if they were not provided. It simply does not fulfil the tests of SIL Regulation 122, and therefore both the primary school contribution and the school transport contribution should be rescinded.
Okay. Thank you, Mr. Hunter. I see Mr. Atterbury's joined us and has his hand raised. So, Mr. Atterbury, did you want to respond?
Yes, good morning, sir, and good morning,
Hello.
everyone else. Thank you. The point Mr. Hunter's just made there is quite right, but actually he's misinterpreting it. And if we just go back to what he said, is if there is capacity in the area, now the area isn't the catchment school, it's actually the 3 schools that need to be considered here, and that's made quite clear within our policy that there's no benefit to just picking on a single sentence without looking at the whole policy in its entirety and understanding exactly the message that it's trying to put across. In this case, Ms Townsend has made very clear that there's a shortfall of 94 places for the 3 schools in the area, which in effect means that the surplus in the catchment school is actually absorbed within that, so it disappears quite quickly, bearing in mind the other developments in the area. The other point to make here, though, and again Mr. Hunter will be very, very cognizant of this, is that the National School Admissions Code precludes the reservation of places within any school, irrespective of whether it's a catchment school or the nearest school. There is sometimes a difference between the two. The other point that we're just touching on there is about the need for transport. Clearly, the local authority does not try and advocate transporting pupils outside of their locality. That creates any number of problems, particularly where families may have more than one child attending different schools. So it's a last resort for us. It's not something we particularly want to do, but it would seem in a situation where schools within a locality have exhausted of their surplus capacity, then we have no other options if those schools cannot be extended. Thank you, sir.
Thank you. So, Mr. Atterbury, just to say, so at one point you said about the surplus being absorbed by the deficit, or the words to that effect. So, so that's slightly different looking to what your colleague might have said or not said. But so you're saying that those 28 places.
Yes. What I was saying there, sir, sorry if I may, is that if we've got a deficit of 94 places, then the surplus that exists in Redlands at the moment, the 2018, is quickly taken up by that deficit of places. So in other words, the demand spilling over from the other 2 schools within the catchment, within the locality, will take up any surplus that might exist in Redlands. It's not a case of saying when we've dealt with that surplus of 94, that deficit of 94 places, that there is still a surplus in Redlands. That clearly isn't the case. It's gone.
Okay, thank you. Mr. Hunter, you have your hand raised.
Thank you, sir. I would first just like to point out there's a lot of discussion about a deficit of 94 places in the area, and yet I've not seen any evidence from Leicestershire County Council demonstrating where that deficit is coming from.
I think we have questions on that, don't you worry.
Okay.
We will come to that, don't worry. But please go on.
Thank you. Obviously, I take Mr. Atterbury's point about admissions criteria, but certainly catchment is often very high up in admissions criteria. Therefore, if this development is within the catchment of the school, then pupils applying that live further away from the school to this development will be pushed into schools into their locality, and the pupils that apply to the school into their catchment school will be higher up in terms of the admissions priorities. Now, obviously, we're talking about there are 3 schools, and no doubt we will go into detail about those 3 schools. Cossington is technically the closest, but is not the catchment area school. So you've got Sileby Redlands, which is the catchment area school, and as of the most recent figures published in the public domain, which is the 2020-2021 academic year, the school was operating with a roll of 366 against a capacity of 420. These figures are included in Table 12 of the Appellant's Proof CD 10.23. And furthermore, and this is a sort of fundamental issue in terms of the figures, we have Highgate Primary School, which is discussed at some length in the council's evidence, That school is, the most recent figures are that it has a roll of 222 against a capacity of 315. So again, quite a significant amount of spare capacity. The only school that is currently full in Sileby is Cossington Primary School. And as discussed, there is a development. There are 2 developments that are contributing specifically towards the expansion of that school, including land contributions. But the fundamental issue is, I think there was a discussion of parental choice, and it should just be noted that parents don't have a choice of where their children go. They are allowed to put forward a preference. The choice is then down to the admissions of Leicestershire County Council according to the admissions criteria of the school.
Okay, thank you, Mr. Hunter. I see that Mr. Tuck had his hand raised. Did you want to say anything before I turn to the council?
Yeah, I did, sir. 2 things. First of all, Mr. Hunter made reference to the planning obligations policy being core document 633. I think it's 634 on the updated version of the council's website for some reason. I'm not sure.
I think I
change.
I have it as an appendix to one of the proofs as well. So I at least I know which document it is. I'll thank you.
That's reassuring, but that wasn't my main point, sir. That certainly wouldn't have interrupted for that purpose. It's really just to pick up Mr. Atterbury's point about read the policy as a whole. Firstly, it's not policy, it's guidance. It's not an SPD. It's not been adopted as an SPD, and it certainly hasn't been viability tested as required by the PPG, and will make submissions in due course about weight. But sir, if you note the question at the end of the table in the summary on page 33, as a simple chap, it allows me to understand what's meant by the foregoing text. And the question at the bottom of page 33, do you have the words, what if there is spare capacity at the local catchment school?
Yes, I have that. Thank you.
And the simple interpretation that one has from that's promulgated by the county council is what contributions are required. What if there's spare capacity at the local catchment school? Contributions will be required for every pupil place required in excess of the projected capacity. Now, with respect, that's our case. It's about as simple as it gets. Is there spare capacity at the local catchment school? Yes, there is. Are the county council seeking contribution for something which is other than contributions for places required in excess of the projected capacity? Yes, they are. Therefore, they're doing something different from their own guidance. So I'm afraid, sir, Mr. Atterbury's wrong. You need to read the totality of this section, but the summary is crystal clear. Now, that said, it goes on to talk about how you calculate projected capacity, and it introduced this notion of net capacity, which it cross-refers to other documentation, notwithstanding the PPG talks about capacity. But sir, it's as simple as that. That's our case, and it's consistent with what the county council has to say, I'm afraid.
Okay. Do you have anything to say about Mr. Atterbury? We said you're looking at the 3 schools across the area. It's not just the single school.
Well, I'm reading from the documentation, sir. And yes, of course, you look at the school planning area, which is what the PPG has to say, but you also have to apply Regulation 122. That's what this document tells you it does. And applying Regulation 122, this is what Leicestershire County Council is inviting decision makers to do, because, of course, this is advice to decision makers. So this is telling the local authorities what you should do with this information. Now, one, of course, understands that the County Council would wish to seek additional contributions to resolve an existing issue, which is a deficit in schools which are not the local catchment school. One understands that in terms of the public interest, but that's not the test. The test is necessity and mitigating the impacts of development. And unless national guidance changes, that's the test, sir, of course, you have to apply.
Okay, thank you, Mr. Tucker. See, Mr. Atterbury has his hand raised. Would you like to respond?
Thank you, sir. Just to refute the comment made there by Mr. Tucker, you'd no doubt expect me to do that. Just to say that he is correct in stating that the Leicestershire Planning Obligations Policy is not policy in terms of national law. I don't dispute that position. Nevertheless, it is a policy of the County Council that's been in place for several years now, and it's been applied to all developments across Leicestershire, including those in Sileby and Cossington, and in particularly including those that have recently been approved in Sileby and Cossington. So it'd be wrong to seek to adapt that policy or overlook that policy, should I say, just to try and deal with a particular development because it may suit the applicant's purpose.
Okay. And anything else from the County Council at this stage, or any response, Mr. Tucker?
Yes, sir. I thought I was clear. Apologies if I wasn't. At no stage did I invite you to disregard this policy, this document. It actually deals with its status in an earlier section. It deals with it at section 2.1. It aims to provide guidance to inform decision makers. I said to you, sir, I will invite others, i.e. the planners, to give evidence as to what weight to give to a document which isn't a development plan, notwithstanding paragraph 34 of NPPF says that it should be. It's not an SPD, so it's not a supplementary planning document, which would have gone through a process of formal consultation and sustainability appraisal. It is a document which has been promulgated by the County Council, who are not making decisions of this nature to inform decision makers. And in relation to this aspect of it, of course it is informative, of course it tells you what the County Council would seek. It is guidance. And in terms of its status, therefore, it's below the level of the development plan, it's below the level of an SPD in terms of the weight you should give to it, but it's nonetheless informative. But you should give weight to it insofar as it's consistent with national guidance in the PPG and the NPPF. So at no stage am I inviting you to disregard it, sir, nor did I say that. I'm afraid it's Mr. Atterbury launching creating a straw man argument.
Okay. Just on the if I go back to the County Council on this page 33 of that document, it talks about the spare capacity at the local school. That if I read that table correctly, that is only referring to the local catchment school. Does it say anything about taking into account other schools in the area, the overall area in that particular part of that table?
So it refers to the Redlands School.
So that particular part of that table is applicable to the catchment school only. Yeah, that's what you're saying, Ms. Townsend.
Yeah. No.
Or not?
No, I'm saying, sorry, as Mr. Atterbury's just reiterated, the 38 places is, sorry, 28 places, I'm getting confused there, is for Redlands. But the overall capacity in that area for the 2 mile radius, which is a walking radius for the schools, for parents to take their children to school, is there is a deficit of 94 overall.
Okay. I think, yes, I appreciate, there's a danger of picking out certain parts of the document.
Yes, of course, yes.
But I just want to understand that particular table is only referring to the catchment school, but the County Council are still wanting me to consider all the schools in the area and the overall deficit that you say.
The overall impact of the area, yes.
Okay. Fine. Well, that probably brings us neatly on to looking at that deficit then, because it's been identified as 94 places overall within the 3 schools, and that's, as far as I understand it, based on a projected deficit of 275 at Cossington and Highgate schools, minus 153 places being funded by 106 contributions, minus the 28 surplus at Redlands equals 94. I hope my maths is correct in terms of at least understanding where that figure comes from. Does that sound right to you, Ms. Townsend?
Yes.
Yeah. I assume, Mr. Hunter, the maths is correct, even if you don't agree with how it's got there.
I think, sir, the fundamental issue here is where essentially those figures are coming from. So yes. If I may refer you to paragraph 28 of the planning obligation position statement.
The county council's statement.
County council's planning obligation position statement, yes, which I believe is CD 8.11.
Yes, this is the one that sets out the 7th of December letter, effectively.
Yes. So paragraph 28, so it first discusses clearly, which we've already covered, the capacity in the catchment area school. It then goes on to say in the second table of that paragraph, that there will be a deficit of 35 children at Cossington and a deficit of 240 children at Highgate Community Primary School.
Yeah.
Now, as you will be aware, the appellants went back to Leicestershire County Council to find out where those additional children are coming from, because currently at Highgate Primary School, the most recent figures that we have, the school has 93 spare places. If that school was then to have a deficit of 240, then that is an additional 333 pupils essentially in the catchment area of Highgate Primary School. Now that is a huge number of children. So what we asked for, and this was helpfully included later on, is the evidence that justified that figure of 240 pupils. The table that was provided is at paragraph 31.
Yes.
Now that discusses a total child yield of 249.6 pupils from all of the developments coming forward within the catchment area of Highgate. Now, as is mentioned in the evidence, and I know that Leicestershire disputes this, there is double counting in that table, because at least one of those developments, with the land off Barnard's Drive of 228 dwellings, is actually contributing planning obligations towards the expansion of Cossington Primary School. Therefore, I would argue that total yield should be lower within the Highgate catchment area. Now, if you were to add, very simply, 249 pupils to the available capacity of that school, you don't get anywhere near 240 pupils deficit, as was previously stated. Now, the table utilised as evidence at paragraph 31 discusses a balance of deficit places of 96.6. Now, Highgate Primary School currently has 93 spare places. So if you were to add the deficit of places to the current roll of that school, it would take the school 3 places over capacity. If you follow my maths.
Yes.
Now, those 3 places could either be accommodated at that school through very slight bulge classes. Alternatively, as has been identified by Leicestershire County Council, there is capacity at Redlands School after this development receives a positive determination. So this has been the fundamental issue that we've had throughout this process, is that we have simply not seen the evidence to justify the figures that have been put forward by Leicestershire. I can't reconcile the deficit of 240 pupils, and if it is a deficit of 96 pupils, well, they can currently be accommodated almost entirely within the spare capacity of the school as it stands, and any additional pupils would then be able to attend Redlands.
Okay.
So this has been the fundamental issue that we've had in terms of just being able to provide an audit trail for the appellants to take back to their landowners to justify these contributions and these figures.
Okay. Thank you, Mr. Hunter. So if I can turn to the County Council and ask for them to respond and to help clarify where the deficit of 240 comes from, please?
Yes, of course, sir. Thank you for that, Mr. Hunter. That's been helpful. From the table 31 that you've made reference to, you're quite right. The Bernards Drive, the yield for the 228 is are the ones that we're looking to make the 105 to Cossington Primary School, and we did actually highlight that to you. Nevertheless, you'll be aware that I think the fundamental question that you originally asked was how it had changed from 400 dwellings and 120 yield from the original response to the increase, and that's why we explained to you all the different applications that have been granted permission. There is one that's pending, the Peashill Farm, which we've taken into account as a cumulative impact, the same as we have done for this inquiry. So that's when that number comes through. You'll note that we've already deducted a number of Section 106 places for Highgate. It has a net capacity of 285 at the moment. It is increasing by 15 places year on year. So by next year, it'll be a 1.5 form entry. We've done that in a phased programme of works to allow for the housing that's already been granted permission and is under construction in Sileby, with the potential of increasing that in the future, but obviously we need to wait to do that until that money comes through.
So before I ask Mr. Hunter to respond, but just still trying to understand where the 240 comes from in terms of the deficit, because the table at the end underneath paragraph 31 show once you take into account the yield and take off the 106 funded places, you have a balance the deficit of 96 places at Highgate.
Yeah, sorry.
But how do you then get to 240 from that?
Well, originally, from the yield from all of those developments, if you see on the table 31, comes to 249. That is slightly higher, and that's because we discovered, you'll see on that table there was a development for 31 places, which was a supplement to an original application, so that got added back in. So from those, so the primary yield for all the developments at the moment is the 249, which is slightly higher than the 240 because of that slight error, as explained. We've got 153 places that have been funded, which we've deducted, which gives us a balance of a shortfall of 96 places.
Is the deficit of 240 on the previous page of your statement taken from that total yield of 249? Because I thought the 240 is like
no. When beg your pardon, sir. When Mr. Hunter asked for the level detail, obviously we went through all of the applications, and you'll notice there's an application P192162 for 31, which wasn't included in the original application, and that's because it was an application within an application that we hadn't seen. That's why it's slightly higher. That's why it's saying 249 instead of the original 240.
Okay. I'm still struggling. The deficit of 240 is based presumably on sort of balance of everything.
Yes. To be fair, what you could, there's still the development for 175 for Peashill Farm, which is phase 3, as I refer to it. That application is still pending with Charnwood, so. So I've included that to demonstrate a cumulative impact, but if you deducted that, it'd still be a significant deficit.
Okay.
Sorry,
please finish if there's anything else.
No, please carry on.
No, I was going to ask Mr. Hunter to come in, but if you have something else to say, Ms. Townsend first, then please.
No, that's fine. Thank you.
Please say. There's always a slight delay on Teams, but I think that, so I don't mean to obviously interrupt. Mr. Hunter, you want to respond?
Thank you, sir. I'm sorry, I still cannot reconcile these figures, and again, this is where the issue has arisen between ourselves and Leicestershire. I do appreciate all the work that Leicestershire has done, but fundamentally, a deficit of 240 places is an additional 333 pupils on top of the current roll at that school. That is over the child yield of 1,110 dwellings, according to Leicestershire County Council's child yield which is fair and average, as we've discussed. Now, the evidence for the deficit of 240 when the school is currently operating with 93 spare places, just the figures simply do not work. And from all of the evidence and the arithmetic that I've sort of been through with you today has suggested that the school is only just forecast to go over capacity, looking at the current roll. 96.6 places is only 3.3 places, 3.6 places over and above the current spare capacity. So I don't see how the deficit of 240 correlates to the evidence at paragraph 31, and how any of that, how you can reconcile that with the spare capacity that is currently in the system at a school with spare capacity in every year group.
Okay. Thank you, Mr. Hunter. Mr. Tucker, do you want to say something before I go back to the County Council?
Yes, sir. Just so that I've got my closing correct. My understanding is that what Ms. Townsend has just said is that I think it's referenced Land at Peacehill Farm P/21-2131-2 isn't a commitment. It's just an undetermined application, yes, and yet the county have included that as part of their figures. Is that right?
I think that's what Ms. Townsend said. Was that right, Ms. Townsend?
Yes, Yes. What I've included, because it's awaiting determination, Mr. Tucker, I've included it to demonstrate the cumulative impact.
Well, I entirely follow that, and I'm happy to draw attention to the PPG as the correct approach in closing. But thank you for the clarification.
You're welcome.
Okay. Anything more to say on the figures for Highgate? Well, I think I'll turn in a minute to looking at the developments that sit within the table below paragraph 31. But I suppose I'm still is there more information behind that 240 deficit figure that the County Council can provide to help me understand how it's got to that figure? Or are you saying, Ms. Townsend, that the table in paragraph 31 is that sort of working out?
Yes, so I'd certainly be able to do that. I'm just needing to switch screens to be able to bring that information back up to explain it in further. But it would just mean that I just need to blank from that screen, if that's acceptable to you, sir.
Okay.
If you give me a few moments, please. Well, Mr. Hunter wants the opportunity to speak first.
Mr. Hunter, is your hand still raised from earlier, or did you want to say something?
Apologies. No, I should have lowered that. I think the point's been made. Specifically, because I don't think anything more needs to be said from me.
Yeah, I mean, I'm not inviting lots more evidence on this, but at the same time, it would help me to understand how the figures are reached for Highgate. So if there is more information that's shareable, then that would be helpful. But Ms. Townsend is probably, you're on mute at the moment, Ms. Townsend, but I don't know if you're.
I think she'll be with you in a moment, sir. She's just trying to sort out a small screen and
that's
technology.
Okay. Thank you.
Just bear with me 1 second. I'll just get that for you.
Thanks.
Can you see that, sir?
Yeah, I'll just have to make my screen slightly bigger, but okay, yes, thank you.
So the way we've calculated that, you see, we've worked on the net capacity of the 285, which I explained earlier, where the Highgate is phasing up to a 1.5 form-entry school. We have the 2-year and the 4-year forecast. We've taken an average of the 231 and the housing included from the developments, which is in the table that was shared, and that gives an average of the 525. Now, taken from the net capacity of the 285, that gives you the 240, if that helps explain that. And then we've got the 106, the 153 places that have been deducted against both schools, because there's right. 106 against Cossington as well, which gives you the overall deficit of 94, of which 75 are already existing.
You say already existing, is that a sort of demographic or existing?
Demographic, yes.
Yeah, okay.
Based on our forecasting
Thank you.
information.
I mean, that's helpful to see. I don't know if Mr. Hunter, you've seen that before.
Yes, sir. I just, unfortunately, the figures here again don't reconcile with the evidence that's been provided to inform this this planning appeal. We have, if you have a look at Highgate Community, sorry, Ms. Townsend, would you mind popping that back up?
Oh yes, of course.
I was referring directly to.
I think if we're going to be using this as evidence, I think I will need a copy of this. But I'm happy to obviously see it on screen for now.
Where's it gone? Where's it gone? Oh, just bear with. Sorry, I'm technically challenged again. There we are. Could everybody see that?
Not at the moment, but
okay.
I can just see a blank worksheet.
So I'm quite conscious that obviously Mr. Hunter and I are in different places, and I don't know if Mr. Hunter's had the opportunity to look at this before. It's certainly not a document I recognise, and it may very well be that Mr. Hunter may wish time to have thought of it, but certainly I would welcome a copy being emailed to me as soon as possible, please, so that I can at least understand it.
Mr. Hunter, have you seen it?
Thank you. Yes. So the point that I would just like to make about this, and this is the first time that I've seen it, but all I can say is that the figures from this spreadsheet clearly are not do not correspond with the evidence provided to inform this inquiry. We have, firstly, they are utilising a net capacity of 285, which I don't think is appropriate, because the school is actually expanding up to 315 and will be imminently. So it does have the ability to be 315. You have pupils, if you have a look at F21, pupils from this development of 294. But if you look at paragraph 31 of the evidence provided, it says a maximum of 249. You have funded places of 114, whereas paragraph 31 discusses funded places of 153. I'd just like to make the point that these figures do not correspond at all with the evidence provided to inform this inquiry.
Okay. Any response, Mr. Townsend? Or
I think, is my microphone on?
Yes, you're on.
Thank you. As previously already commented on, I think the part of the discrepancy will be the cumulative impact from the Peasall Farm document that we've already said. I appreciate what Mr. Hunter's saying regarding the net capacity for Highgate, but the reason we're doing that phasing is because, of course, schools get funded for pupil places, not for their capacity. So you need to take into account, of course, the funding that the schools receive to employ teachers and to fund their infrastructure. So in terms of that, we do that on a phased basis. We wouldn't be able to, like if you were opening a brand new primary school, for example, of a 210 places, you wouldn't have that capacity at 210 immediately, because the schools just wouldn't have the budget implications to fund all the staff for those spaces.
Okay, and just understand that the reason why the county council uses net capacity rather than actual capacity, what's the reason for that?
The reason we do that is because each year we consult with academies and mainstream schools about what their admission number is going to be each year. Now they base that again on their own forecast information they have, and then they set their admission number accordingly. So at the moment for Highgate, they have an admission number of 45 in reception, year 1, year 2, year 3, and then the remaining year groups of year 5 and 6 will be at 30 as previously had, because to allow those year groups to work their way through.
Yeah, I understand that.
Thank you.
But do you accept the opponent's point that one could use the actual capacity when looking at school places?
No, not necessarily, mainly really for the example that I gave you before, because the schools are not funded on their capacity. They're funded for the number of pupils they have on roll, and part of that funding goes towards funding teaching staff. So if the schools would end up in a deficit budget if you were working it on that way.
Okay, thank you. I see 3 hands raised. I think if I take them in the order that they were raised, Mr. Tucker, I think your hand was raised first.
I can't see the screen again, actually. Excuse me, sir. Sorry to interrupt. Am I okay to close my screen now so I can join the meeting again?
Are the parents happy for that? Do we need to refer back to the screen at all? Or, yeah, okay, that's fine, Miss Townsend. Thank you.
Thank you.
Well, I'm happy for Ms Townsend to close the screen, but I wonder if perhaps we might just have the opportunity for that workbook to be sent to Mr Hunter so that Mr Hunter can have time to look at it, because that seems to be fundamental to the 240 figure, and the 240 figure is quite an important point. What I understand from what Ms Townsend has just said is that 240 figure also includes the unconsented phase 3 Peace Hill, and that therefore there is an issue in terms of whether that's the right issue. In terms of how net capacity is assessed, sir, that's an interesting point which is discussed in the obligations document, but you'll of course note, sir, what the PPG has to say, and we can make submissions about that in due course. But so I would very much welcome the opportunity for that workbook to be sent to Mr Hunter as soon as possible, please.
I mean, the County Council are happy to provide that as a PDF or something like that.
Excuse me, sorry, sir, I had my mute again. Yes, of course, I can send that through to Mr.
Okay.
Hunter.
Okay, thank you. Mr Hunter, your hand's up next. Did you want to?
Yes, sir. Just a very quick point about the capacity of Highgate School. By the time this development is building out and generating children, it will have that school will be operating at a full 315 pupil places. It does have the ability and the to accommodate that number now, and if I could just actually refer you to this point, because this will be very important when it comes to the secondary school position, that the admission number is not reflective of the actual capacity of the school and can be changed. If I could just flag that now, because that will be later on.
Yes, I think you've made that point, I think, in your evidence. So, but thank you for making it again. Mr. Asprey, you have your hand raised as well.
Thank you, sir. I was just going to continue the debate around capacity. As someone with 48 years now experience of working closely with schools, I definitely understand capacity matters. And the point to be made here is that there is a difference between the maximum capacity of the school, in other words, the amount of pupils that could physically be pushed through the front door, and the optimal capacity at which a school could effectively function, i.e. the net capacity, which is why we have those conversations with schools. And the net capacity reflects, as Ms Townsend was partly explaining there, the fact that a school has to effectively function based on the needs of its pupils, its curriculum provision and its available resources. So it will always operate below its maximum capacity level. That just isn't possible for any particular school to operate in that way. As I say, it would require a much more detailed debate around the curriculum provision, the needs of each child within the class, and how the spaces are configured within the school building. It's not just a simple calculation of saying the square meterage is X, so the number of pupils are Y, which I think is the approach probably being adopted by Mr Hunter and others.
Okay, thank you, Mr Asprey. Any response from the appellant?
So yes, just to say that schools can take over their admission number if they choose to. Many do. There are lots of schools that operate, for example, with 30 pupils per year group, but their physical capacity is lower than that. But they feel that schools are sufficient and appropriate to run above their capacity. It does make sense for schools to operate with as many pupils as they can physically accommodate, and while still being able to provide a good standard of education, because schools are funded on per pupil. So in order to maximize their effectiveness and efficientness, it's better for schools that they are operating at their practical capacity.
Okay. Anything else to say on capacity issues before we go back to some of the data, Mr Atterbury?
If I may come in there, sir, yes, there are schools that do sometimes operate above their capacity, and I'm also head of admissions for my sins. So Yeah, I don't disagree with that point, but it actually comes down to the type of pupils, which classes they're moving into, and their particular needs. So I wouldn't want us to get carried away with the idea that there are lots of schools in Leicestershire operating above their capacity limits. There simply aren't.
Okay. Thank you. Then I think if we just do a little bit more, hopefully we can get to the end of primary education, and then I suggest we then have a break. But looking at the table of developments that's informed the figures for Highgate, thank you for clarifying where some of these applications are at in terms of, thank you to the County Council for clarifying where some of them have got to in terms of planning permission. I mean, I assume the parties agree that if something has planning permission or a resolution to grant planning permission, then it can be taken into account as part of the sort of yield figures. I appreciate that the undetermined Peasel Farm one that parties might differ on that, but Mr. Hunter, is that right? If something's approved, got planning permission or a resolution to grant, it can be taken into account in terms of pupil yield?
Yes, sir, I accept that. Okay,
obviously the County Council provided those schemes. I suppose, yeah, the reason why I asked that question was I wanted to be sure whether all those different applications did have permission or a resolution to grant or not, because there may well be implications on the yield figures. But is it the case that only the land at Peasel Farm is the only one that's pending apart from this scheme, Ms. Townsend?
Yes, that is correct, sir.
Yeah, and the appellants don't come to a different view on that, take a different view, Mr. Hunter?
No, that's correct as far as I'm aware. That's the only outstanding one in terms of in terms of approval.
Okay, thank you, Mr. Thomas.
Yes, thank you, sir. I just wanted to say in relation to Peasel Farm, I mean, just in general terms, it's quite difficult when planning for school places, because planning permissions are all at different stages, and quite often there are other speculative developments coming forward that we need to take into account. And for that reason, it's not uncommon, and I think this applies in this case as well, that the draft agreement, Section 106 agreement, will include a clause that money is paid back in the event that another development comes forward that funds those school places. So the money that's requested is only ever required for the improvements that provide the necessary capacity. We would never ask for additional money above and beyond what is required if that funding is coming from another planning permission. So you always get this situation where some developments will come forward at different stages and where planning permissions are at different times. And so factoring that into the wording of the Section 106 agreement is important, so that we're not double counting or asking for too much money, in the same way as we don't want to under request the contributions that's required. So my understanding is in the draft Section 106 agreement, there is provision within there that in the event that the Peasel Farm development does come forward first and makes the contribution, then the contribution will be adjusted accordingly.
Okay, thank you. Any response, Ms. Hunter, or are you happy with that?
I am happy with that. It's mainly the issue of this really comes down to a very simple point, which is that the catchment area school has capacity to accommodate the entirety of this development with spare capacity following a positive determination. It really is as simple as that. And I'd still, even throughout the discussions today, I cannot reconcile the figures attached to the developments, whether you include Peasel Farm or not. It's the figures simply don't quantify the entire planning area going over capacity at any point.
Okay, thank you. I think I wanted to briefly talk about Cossington's capacity. Conscious that we're nearly at 11 o'clock, are we happy to maybe deal with Cossington and then have a break and then come back to talk about primary transport and the other contributions? Everyone's happy. So the Barnards, I want to understand the Barnards Drive site. There's this question I had about it appearing in both the table for Highgate and Cossington. In terms of its yield, Mr. Townsend, where's it being kind of sort of put?
Apologies, sir, that one did seem to be quite confusing. What I was trying to demonstrate, I think from the original the original correspondence from Mr. Hunter was suggesting actually that if the outcome of this was a positive one from this appeal, that those places might be considered for Cossington, and made reference to the Humble Lane application. I merely made reference to the fact that the Berners Drive application is being taken into account for the 105, the half form entry that will go to Cossington already. So we'd kind of already highlighted that, and that does form part of those 240. It isn't double counted. It's just to explain that actually the yield from that 228 is going towards the half form entry at Cossington Primary School. Does that help, or have I just?
I think so. So no, it's okay. I think if I've understood it, then so Barnard's Drive, the yield from Barnard's Drive has been
we've apportioned it towards
Highgate, but
it's been as the encatchment school. So yes, we have. But what we've done is we've apportioned that to justify the half form entry to Cossington because of the number of places. Otherwise, it just wouldn't be worth. Obviously, from a school organisation point of view, to be able to make that work.
Okay, so the deficit. So yes, the deficit that Cossington has of 35 is based on. So so Barnard's Drive isn't contributing to the Cossington deficit of 35. Then it's contributing to the Highgate deficit.
It's contributing to the Highgate deficit at this moment in time.
Yeah.
And then obviously that will go towards the Cossington one. The 35 deficit we've got there is for the Humble Lane development that's already been granted at Cossington. Sorry, that wasn't very clear.
No, I can see that yes, because the yield from Humble Lane is 39.
Yes, so that's
with some rounding up and
yes,
slightness.
So that's where that deficit comes from. So
okay, because Cossington is effectively at capacity now.
Yes, it's a very small half form entry school, which of course I'm sure you'll see when you have your visit.
Okay, thank you. That's helpful. Does that any comments on that from Mr. Hunter?
I don't believe that the sort of expansion of Cossington really has any bearing on whether planning obligations are applicable to this particular development. As discussed, it's a small school. Specifically for Cossington, there are 2 developments which are coming forward with approximately half a form of entries worth of children pupil yield. The County Council has agreed with those developments to expand that school in accordance with their yield. Therefore, they should ultimately be discounted. And then we look at the remaining available places, the catchment area school, and whether there are likely to be sufficient places in school for the pupils of this development. So whilst it fills in the gaps in terms of giving you the entirety of the impact on local schools. I don't believe that it actually has any impact on whether planning obligations are required from this development.
Okay, so you're saying the Barnard's Drive yield shouldn't be taken into account against Highgate's?
No, certainly not. I mean, from my perspective, it is double counting. So that should come out. Then there's also obviously the question about Peace Hill Farm in its current state as to whether that is an approved development or not, as whether that should be included. So when you remove 2 significant developments from the impact on Highgate, that further diminishes the forecast deficit of places. And which should actually take the school significantly under its capacity of 315 places on the basis it currently has a roll of 222.
Okay. Ms. Townsend, should I disregard Barnard's Drive's yield from the Highgate deficit then?
By all means, you're right. We can deduct that, but I think we'll still have an overall deficit of places in the area. What if I could suggest, sir, and if Mr. Hunter is in agreement as well, when I send the information over to him, which I'll perhaps do it when we stop for a break, if we see the impact of I can certainly remove the Peas Hill Farm and that one, and we'll look at the overall deficit. But I think you'll still find there's a deficit of places in that area. But we're happy to pick that up with you if that's acceptable.
Okay. No, I'm certainly happy for the parties to discuss offline any revisions to figures and where possible, agree on them and present them to me, because that obviously will help me.
Yes,
I'm
of course.
sure. Thank you. Mr. Tucker?
Yes, sir. Just in response to Ms. Townsend, that would be extremely helpful. Thank you very much indeed for that offer. That's helpful. I don't know if it would also be possible to do a second run which shows the issue of the 315 against the 285 capacity point that Mr. Hunter also made. I appreciate that's not agreed by the County Council, but in terms of showing the inspector the maths, I think that might be helpful as well.
Yes, I could do that for you, Mr. Tucker.
Thank you, Ms. Townsend.
Thank you. Thank you. Very helpful. So just final thing on Cossington, I think there has been some discussion in the evidence about the further expansion of the school. That, you know, is that hypothetical rather than likely at this point in time, given that this proposal contribution is not earmarked for Cossington, and although it does have that flexibility of potentially being applied elsewhere. Mr. Hunter or Mr. Aston. So Mr. Hunter, first of all, I think you.
Yes, sir. Well, it was put to us in the evidence that there could be the potential for expanding Cossington beyond 0.5 forms of entry. As discussed, I don't think that is necessary to take into account on the basis of spare capacity in the catchment area school following a positive determination of this development. However, it does indicate that, you know, there are other options for the county council should that be required. Specifically and predominantly should that be required if Cossington was to expand. From what I understand, there is a request from Leicestershire County Council for 1.2 hectares of land adjacent to that school to allow for an expansion. You could put a new one form entry facility according to Building Bulletin 103 onto 1.2 hectares of land, which would allow for an expansion beyond 0.5 forms of entry for that school, should it be required. But ultimately, it's beyond the sort of the scope of whether planning obligations are required against this development, because it's predominantly a Cossington school.
Okay, Mr. Asprey,
Yes, if I could please, just to address some of the points made there. Yes, Mr. Hunter's correct that it was suggested as another option. It's not one that the County Council would recommend because Cossington Primary is located in a conservation area. Its costs to extend even further to accommodate this development therefore would be significantly higher than those currently being requested by the County Council. The key issue here is that Mr. Hunter has incorrectly stated that 1.2 hectares of land are being made available. That is not the case. It is 0.6 of a hectare. If we were to seek to extend Cossington, and there's a certain logic to that because it is the nearest school to this particular application site, even though it's not the catchment school. But if we were to seek to extend the school, and we'd gladly have that conversation if that's what the applicant wishes to talk about, it would mean not only the cost of buying another 0.6 hectares of land, but whatever the owner's set as market value, plus the cost of extending the school. So we think it's not really a viable option. It will cost an excessive amount to the applicant, but nevertheless, if they would like to have that conversation, then we're very open to have it.
Mr. Hunter.
Okay.
Thank you. I'd just like to point out there's a couple of points on that. Firstly, we haven't ever raised the need to expand Cossington to accommodate the pupils of this development. I think it's been clear from the council's evidence that the catchment area school has sufficient places. I think Ms. Townsend will be able to confirm that Leicestershire County Council, whilst the development may have 0.6 hectares on its master plan, Leicestershire County Council requested 1.2 hectares in their consultation response to that development. And I also believe that there is a committee resolution to provide 1.2 hectares, and that's why we're referring to that. And hence the reason that's why it's been discussed. But ultimately, the concept of expanding that school beyond 0.5 hectares was raised by Leicestershire and not by the appellant.
Okay, thank you, Mr. Tucker. You want to come in as well?
Yes, so just to say that point about the fact that the resolution to grant containing the figure of 1.2 hectares comes directly from those instructing me. We can turf out the resolution to grant and provide that to the county council and yourself over the break that we're about to have, if that will be helpful, sir.
Sorry, so just clarify what you meant by that, Mr. Tucker.
The resolution, my instructions are the resolution, forgive me. So the committee resolution is 1.2 hectares, and I was offering to provide that resolution to all parties. So at least there's clarity that that's the formal position. It may be that's been amended behind the scenes. I don't know. And that's always possible, but that's certainly the basis of the information of my witness. Sorry, core document CD 7.01. Ms. Smedley is extraordinarily efficient in these matters, so all parties can check it.
That's the Humble Lane report we're talking about.
Yes, sir.
Yeah. Okay. Thank you, Mr. Thomas.
Thank you, sir. Yes, that is absolutely right, of course, and thanks for clarifying that, Mr. Tucker. The situation is that while that additional land was requested, clearly it's only a 0.5 form entry extension to serve that development, and therefore the ability to secure the additional land is still subject to discussions. It's only got a resolution. My understanding is it's not got a signed section 106 at the moment, and that's subject to discussions with the agents representing the developers in that case. As Mr. Atterbury's pointed out, the site is in a conservation area. It's very challenging to develop in a way from a planning point of view that would be acceptable. Although from a sustainability point of view, I would argue as a planner that having an extended school so close to this site is preferable than taking children and busing them to a site much more remotely, partly to encourage people to walk to school and also from a sustainability point of view, people not using the cars. But that's not what's in front of us today, and that's not the issue. So thank you, sir.
Okay, thank you, Mr. Thomas. Mr. Hunter?
Well, obviously we're going to be getting onto sort of primary transport, but I just to state there is no indication that children will need to be bused because there's going to be capacity at the catchment area school. I feel I'm labouring this point somewhat, but I think it's really important one to make. There is forecast to be spare capacity at the catchment area school. Therefore, there is no need for busing children out of Sileby.
Okay, I think if you hold that thought, we'll probably come back after the break to talk about the primary transport contribution. But I think if there's anything else to say on the primary education contribution at this stage, I think probably now is a good point to have a break, and then we'll come back to discuss the remaining education contributions. Is there anything before we break? Obviously, there's a few things to be sort of shared, or at least the spreadsheet to be shared. But I think otherwise that's probably everything for now. So if we break, everyone happy with a slightly shorter break, and we come back at 11:40 to carry on? Yeah.
Yes, sir.
Okay. Thank you then. So we'll adjourn then until 11:40. Thank you.
Thank you, sir.
Hello, everyone. It's 11:40 and the inquiry is resumed. Are we happy to carry on, continue? Yeah, everyone around. Okay. Just during the break, just picking up on a few things that have been emailed through to me. So I now have a replacement map for ID4, which shows the site on the southern edge of Cossington. So that can replace the earlier version that we had. So thank you for that. I've also been given an updated clean version of the section 106 dated 22nd of March, which I'm happy to substitute for the earlier or yesterday's version as inquiry document 5. I think it's just had one thing changed, but we can talk about that in due course. And then I've had an updated condition schedule from the parties, which we'll come to in due course. Are there any other procedural matters or documents before we carry on with the roundtable? Anything from the appellant, Mr. Tuggett?
Sir, I've got a personal question to ask, which is whether you're happy to dispense with jackets. One never knows what the temperature is in everybody else's room on days where it's held virtually, but in my room, I'm in an oven. So if you're happy to dispense with jackets, that will be welcome, sir.
I'm fine with that. I think yes, it's an unusually hot March day for a lot of places. So if you need to, then please do.
Thank you, sir.
Thank you. Any other procedural points from anyone? Okay, so if we carry on, I think hopefully we, you know, in terms of the remaining items to cover, it hopefully won't take as long as perhaps the primary contribution did. So, Ms. Townsend, you have your hand raised.
I beg your pardon, sir. I just missed the opportunity. I'm just working through that information that I promised I'd send through. It's just that making a quick drink and respond. I haven't had enough time to send it. I'll do that by the end of today.
That's fine. I think when we get to the end of this session, we'll have a sort of wrap up as to what we're what's happening next in terms of figures. I wasn't necessarily expecting answers immediately, but Mr. Tucker may have a view on that.
Yes, sir. I'm content with that. Our thoughts were that had that landed just before we were restarting, so I was expecting it to just be a press of a button, but it's not because there's some reworking. That the best way to deal with that would be for Mr. Hunter to provide a short written response to any additional points which arise from it. And hopefully it can just be dealt with in writing rather than reconvening the session, which probably works around and perhaps takes a little pressure off Ms. Townsend.
Okay, the County Council happy if Mr. Hunter provides a note?
Yes, certainly, thank you.
Okay, fine. Well, we'll discuss the sort of timetabling for that at the end of the session. But okay, thank you.
Oh,
thank you, sir.
Anything else from anyone? Okay. I think one thing, just before we move on to primary transport, I did just want to just cover a point that I forgot to mention before the break, which was about the scope to improve or remodel Redlands. I think obviously a point was made before the break about Cossington expansion. There may be issues there with the location of the site, and I think some interested parties have raised this as a concern as to whether or not you can expand or alter Redlands. Is that a concern that the County Council has or not, Ms. Townsend?
Thank you, sir. The Redlands site is a challenging one. That doesn't mean to say that it couldn't be, but what I need to point out is that Redlands is run by the Discovery Academy Trust, and they would not increase their capacity by half a form of entry. They would want to increase by a full form of entry, which in effect would take the school to a 3-form entry of 630 places. Now, they have independently looked at drawings, which they do for all of their schools across their trust, and their QS is costed for that scheme would be £5.5 million. So you're actually looking at almost the cost of a brand new school, and certainly not something that would be, I'm sure, wouldn't meet the SIL tests, I'm sure.
No, I mean the contribution that's being sourced obviously would be put towards improvement works at Redlands, or failing that another school nearby.
Yes.
Yeah, I mean we can obviously we're going to talk about the 106 separately, and I don't know if I assume the County Council will be represented at that discussion as well.
I think the point I was trying to make is that Redlands won't have already said through their Academy Trust, the Discovery Academy Trust, that they would not increase their capacity by half a form of entry. So for the benefit of this discussion.
Okay. Thank you, Mr. Hunter.
Apologies. Thank you. Just to say that I don't know whether obviously we've discussed whether it's the potential for Redlands Primary School to expand, but whether the actual business case would support expansion on the basis of spare capacity is an important point to make, because as stated, the school is currently under capacity. It's operating with 366 pupils against a capacity of 420, and is still forecast to have capacity should this development have a positive determination. So the business case and the justification for potential expansion of that school has yet to be established.
Okay, thank you. And any response from the County Council, or are we happy to move on? I suppose the question I have is obviously if the money wasn't spent at Redlands, where would it more likely be spent? And obviously the 106 allows for that flexibility. So
If I may come in there, please.
Yeah.
There's two questions. First of all, I think the comment about Redlands is a very subjective view, and yes, there would be a business case to validate the need for expansion, but at the end of the day, this is an academy we're dealing with. They have full control of their site and their admission numbers, in so much that they are an own admissions authority. So I don't think we can suggest anything in terms of Redlands until that detailed conversation's taken place with the Academy Trust. In terms of the other point you raised there about where might the pupils go if they don't go to Redlands, I would say it's not possible to say that with any certainty at the moment, other than to say that we expect that they would travel outside the area. The reason I say that, of course, is it depends on when this development commences, the speed at which occupations are then taken up, and any material change that may take place in terms of the capacity of schools within a reasonable radius of the applicant site at that particular time. So I think all we can safely say at the moment is that those pupils coming from this site will be travelling in excess of 2 miles to get to the nearest available school there. As we know things. Thank you.
Thank you. I suppose the question was more about where the contribution towards primary education might be spent if it wasn't spent at Redlands. Can you help that at all?
In some respects, it's the same sort of answer. We wouldn't know yet until we looked at the data for all the schools and started a conversation with a particular school about whether they had capacity to expand or not. Bear in mind that, and you'll see this when you visit the locality, the applicant site is in a rural area surrounded by many schools of a rural nature. So the constraints that may apply to Cossington, for example, could equally apply to nearby schools. And if we start to look at schools nearby, and I think Mr. Hunter's already made reference to this in his proof of evidence, Rothley Primary School, probably pronounced Rothley at your end, is within a reasonable distance. Nevertheless, it has its own pressures. It is a heavily oversubscribed school on a constrained site. So I think the point I'm making here is there's a piece of work to be done there if that is the situation in which the County Council finds itself.
Okay, thank you. Mr. Hunter?
I don't think I have anything else to say on the primary school aspect. I think all the points have been made.
Okay, thank you. So we just briefly talk about this. To move on to the primary transport. So the County Council, this is being sought on the basis that the schools within the 2 mile radius of the site would be at capacity. So is that correct? Is that why that's being sought?
Shall I address that one, sir?
Yes, go on.
I think that's correct. And as I said earlier on in this discussion, that is an absolute last resort for the local authority. It's not a position that we would advocate. It causes significant disruption to both families and particularly pupils. So when we talk about transport, based on what we know at the moment, we expect that the solution for pupils arising from this development will be in excess of 2 miles. As Mr. Hunter will know, and no doubt Mr. Tucker, is that in law, the DfE make clear that pupils living more than 2 miles distance from a primary school have entitlement to receive transport assistance. If that situation therefore arose, then it's reasonable that to mitigate the impacts of this development that the County Council should seek transport costs from the applicant. We have said, and just to clear up some ambiguity here if it does exist, that we have said previously that those costs should be in perpetuity. In actual fact, what it actually means is that those costs would be applied for a period of 7 years maximum. Now, of course, we are prepared to keep an open mind on this, and certainly as the development progresses, we will be tracking pupils just to see where they are moving off to. And again, a point my colleague, Mr. Thomas, made earlier, if there isn't a need to claim funds, then the County Council will not do so. We're not a profit-making organisation in that sense, and there's nothing to be gained by seeking a contribution that then we don't particularly need.
Okay, thank you. Mr. Hunter.
Thank you, sir. I think the fundamental issue with regards to school transport is that Leicestershire County Council have demonstrated very clearly that the catchment area school to this development will have surplus capacity should this development receive a positive determination. On that basis, there is absolutely no need for school transport contributions. And just a second point, Leicestershire have also, I don't believe that in any of the evidence have ever stated where the pupils will go. That will be supposedly bussed out of Sileby. So again, it's very difficult for the developers to be able to provide that sufficient audit trail back to their landowners to be able to assess whether these contributions are required and if they can actually be utilised. But the fundamental issue is, as I think we have demonstrated throughout all of our evidence and has been discussed just in terms of the figures at the schools in Sileby, is that the schools based on development coming forward are not forecast to go over capacity. And if that is the case, then there is no justification for school transport contributions.
Okay, thank you. Mr. Atterbury.
Thank you, sir. I think Mr. Hunter's made the point several times now, and I don't wish to delve into it about the capacity of Redlands.
Yes,
I think we've
had that conversation before.
Yeah, absolutely. We've made our position clear on that.
Yeah.
Nevertheless, there is a consideration here, and I think we've just touched on this, that if it were possible to expand Redlands, then that would certainly be preferential to the local authority. And if we were able to find a way to make that happen with the Academy Trust, and there's certainly a conversation to take place there, I'm happy to pick that up. Then, of course, it would negate the requirement for transport because the school would be within 2 miles of the development. In terms of Mr. Hunter's other question, obviously, I said a moment ago that we cannot say with any absolute certainty what school these pupils may travel to. That will come down to parental preference as well, in accordance with the admissions code. However, if I were to be pressed, I would probably say they'll either be heading towards the Loughborough area, which is 4 or 5 miles up the road. I've not gone out and actually counted the distance, or potentially the East Goscott area would be one of the nearest settlements where there might be places. But again, it's subject to what's happening within those particular areas in terms of housing applications and pupil migration. I say we're trying to second guess a situation which is probably 1 or 2 years off potentially, and things, as Mr. Hunter will certainly know, change quite rapidly within schools.
Okay, thank you. Any response, Mr. Hunter?
No, I recognise that things do change with regards to schools, but the fundamental point is that I just don't believe that the burden of proof has been demonstrated that there will be harm caused if contributions are not provided for school transport. And again, we've discussed potential further expansion of primary school, for example. That was put forward by Leicestershire County Council, and as just a further option, we don't feel that is necessary to accommodate the pupils from this development. However, all that does demonstrate is that there are a number of options for Leicestershire, and busing children, which is going to be hugely unpopular outside of Sileby, it should be the absolute last choice.
Okay, thank you. Mr. Thomas?
Thank you, sir. There's 2 points. One, I was going to just make reference to the planning obligations policy, which we spoke about a little bit earlier. So I think it's paragraph 31 on top of page 18B, which sets out the County Council's approach to requesting contributions to school transport where the school that's being additional places are required is outside the 2 mile range. And it also talks about the 7 years issue that Mr. Atterbury spoke about earlier in terms of what the maximum amount of time we'd require the contribution for, which I'm presuming you're aware of anyway. The second point, just I suppose, just in terms of Mr. Hunter's comment there in relation to, well, first of all, I think that the council's position in terms of the requirements in terms of the schools cumulatively and looking at the other developments has already been considered. So I didn't necessarily need to consider that any further. But if there's any other questions, I'm sure Sharon can clarify.
Thank you. And then, Mr. Tucker, did you have a comment? I know Mr. Hunter's hand's still raised, but that might be from earlier.
Yes, sir. Ironically, I was going to draw your attention to the 2 references in the obligations guidance Mr. Thomas is quite right to draw your attention to paragraph 31B. So he's stolen my thunder in that regard, which is that transport is funds will be sought where it is not possible to provide additional school places within an available walking route of the new development. And it goes on. And then, so I was also going to take you to paragraph 65 of the same document.
Okay.
If I can just highlight the relevant part, forgive me. Just speed of scrolling is slightly different from speed of turning over pages. And then it's the last sentence of paragraph 65. Obviously, you read all of 65, sir, which tells you about the county's mainstream home to school transport policy, which says that it only provides free transport to the nearest available school, further served to render the application of past practice more difficult. So the approach that the county is to seek funding for its policy, but its policy only engages where it's taking children to the nearest available school. And so you'll be mindful of the obvious point that arises from that if there are available places within the catchment school. But I won't repeat the point that's being made.
Okay. Thank you. Mr. Asprey?
Just to clarify a point there, if I may, that Mr. Tucker made, the actual wording of the school's home to school transport policy, not what it says within the planning obligations policy, is it's the nearest available school having a place available. So in actual fact, it's not just the nearest school, it has to physically have the place available. And I don't wish to get into the discussion again about Redlands. We've had that one, please. Thank you.
Okay, yeah. Okay.
Nor I, sir, but that rather makes my point. So I'm grateful for the clarification. You don't have that transport policy, but it is actually footnoted on a hyperlink. But it may be useful, given it's just been referenced, to have that page put before you, sir.
Okay, I'm happy for that if parties wish to provide it. Thank you. And just to understand, final point on transport is the question for the county council. So if you're seeking a school transport contribution as well as a primary education contribution, is that sort of trying to sort of tackle the issue twice, or are you seeking both as sort of the transport as a sort of backup in case you can't do the expansion works?
No, what we're saying is if we have to transport pupils to a nearby school, we'd have to look carefully at if that school had capacity to expand. If it had capacity to expand, well, obviously, if it has available capacity, then we'll discount that available capacity. But if we have to do some expansion works at that school, then we'd also seek a contribution for that works also. I say we'd do our utmost to find a school within a reasonable travelling distance which had some surplus capacity. But in the world of primary schools at the moment, and again, Mr. Hunter will know all about the nuances of the primary bulge. We won't talk about that. Spare places in primary schools are very thin on the ground at the moment.
So it's potential that both contributions could be utilised.
Exactly.
Okay. Thank you, Mr. Hunter.
Thank you, sir. I'd just like to I suppose, reiterate the point that you just made about essentially if all the schools were full within Sileby and there was no expansion potential, but there was a school outside of a 2-mile walking distance that could accommodate those pupils, then it would be appropriate for school transport costs to be sought to go to that school that has the spare capacity. I have no issue with that. However, I think the point is very important that yes, Leicestershire County Council are asking to expand a school within Sileby, assumingly within Sileby, to accommodate the pupils from this development. And obviously, we've had the argument about whether that is appropriate or not, and we differ. But they are asking for money to expand a school in Sileby, and then money to transport pupils outside of Sileby. And so ultimately, it feels like it feels like almost double funding or double dipping, somewhat.
Okay, thank you. Any response, Mr. Asprey?
Yes, if I may, sir. We've not actually said that. What we've actually said is we're asking for money to expand a school without stating where the school is, because we've had that conversation. We don't exactly know where it'll be yet. But we're working in the expectancy that the school will be 2 miles distance. I'll come back to the point I made earlier. if there is potential to expand the school in Sileby further, then we'll certainly explore that. It's unfortunate in some respects that Mr. Hunter has come very late to the table in terms of the conversation about this development. You know, had this taken place prior to January when Mr. Hunter was engaged, then maybe would have identified a solution that saved us all a lot of time and effort. But there we are where we are. But no, we've not said that we will take a contribution to expand a Sileby school. What we've said is we need a contribution to expand the school. There is a point I'd like to make here, though, that expanding schools doesn't happen overnight. And it may well be the case that if we set out to expand a school and the development proceeds at a pace, then we will need to temporarily transport pupils outside of the area. So in that context, it would also be appropriate to request a transport contribution as a temporary measure, so not for the full 7 years, but for a shorter period. And again, that's consistent with our planning obligations, well, guidance, as Mr. Tucker's now referring to it. I'd call it Leicestershire County Council policy.
Okay. Thank you. Anything else to say, Mr. Hunter?
No, I think that's. I think all the points have been made.
Okay, thank you. So if we're happy to move on to secondary education, and I think some of the issues I had have been helpfully covered by the conversation we had before the break. So obviously Humphrey Perkins is the catchment school for admissions purposes, and there's been an issue about the net capacity versus actual capacity, but I assume it's the same argument for here as it was earlier in terms of Highgate, that the Humphrey, Ms. Townsend may be able to help. Humphrey Perkins obviously has an actual physical capacity, but it has a net capacity presumably based on what the school admissions numbers are. I
think. Oh, sorry. Are you happy for me to speak now, sir?
Yes, go on, Ms. Townsend.
Yeah. Yes, certainly. I had a quick look, obviously from Mr. to see where Mr. Hunter had got the 995 from for Humphrey Perkins. So, and obviously that's from the SCAP return that was submitted in 2019. And I think that capacity, the school's capacity is 900, and I think that's the original one was at 995 because it was the tail end of a school reorganisation. Humphrey Perkins was a high school. It was a 11 to 14 school, and a lot of our secondary schools have reorganised in the area to become an 11 to 16. Now, what that means in effect is the high school is now an 11 to 16 school with an admission number of 180 per year, giving it 900 overall. But what it won't have had when it made that change to an 11 to 16 school is sufficient specialist places such as science labs and teaching spaces. So they will have had to have reorganised and remodelled the school to reflect that. So whilst Mr. Hunter is right in what he said from the information he's had available to him, that position is now, as we've stated, that the capacity is 900 places. I hope that you find that helpful.
Okay, thank you. Mr. Hunter, any comments?
Yes, certainly. I think that it's if you take a step back beyond the school capacity submission, which gives you a figure of 995, which would allow the school to have an admission number of 199. When the school actually became an academy in 2018, its funding agreement for Humphrey Perkins School states that the capacity number of the school is 1,106 for pupils aged 11 to 16. Now, where we seem to have problems here is reconciling the numbers, because Humphrey Perkins in their funding agreement state that the school has a capacity of 1,106. The school capacity submission in 2019 from Leicestershire County Council details the capacity of the school at 995. We use the lower number, but what this demonstrates is that there seems to be significantly more capacity in Humphrey Perkins School than is actually being reported. The issue, and I've touched on this before, with admission numbers is that admission numbers can be manipulated, they can be changed. If you have a look at the current roll at Humphrey Perkins School. So if I could refer you to the appellant's proof CD 10.23, and it is table 15. Humphrey Perkins School, on the basis of an admission number of 180, has spare capacity in every year group. It's under capacity in every year group. The published capacity, which is there is a statutory instrument for establishing what the actual capacity of the school is, agreed by Leicestershire County Council in 2019, details 995. There's been nothing that has been shown to us that demonstrates anything other than they have taken the current admission number of 180 and multiplied it by 5. And it would make sense from Humphrey Perkins' perspective to keep their admission number as low as possible, because otherwise it looks like the school has a lot of surplus capacity, and then also that has implications for staffing levels and things along those lines. So it's all the evidence that I have seen is suggesting that they're keeping their numbers artificially low, and that they have the physical ability to grow within the existing footprint of the school. And we haven't been presented with any evidence to suggest otherwise. On that basis, based on the projections provided by Leicestershire County Council, that school never goes over capacity, even when you add in all of the developments that are coming forward within the catchment area of that school. That's the first point. That's the first sort of fundamental point. And then also, as you're aware, we have a secondary point, which is also very relevant to this case, which is actually the school that is geographically closest.
Yeah, we'll come to that point in a while, but thank you, Mr. Hunter. Mr. Atterbury would like to respond.
Yes, thank you, sir. I must admit, I'm a little bit perplexed and possibly bemused by the argument being presented here. On the one hand, Mr. Hunter's presenting the case that a school should seek to artificially suppress its admissions to generate a claim, and yet a short while ago we're having an argument or a discussion suggesting a contrary position, that primary schools would seek to take as many pupils through the door as they could to make their position viable. So the two things are counterintuitive, really. What I would suggest, though, is the point that Ms. Townsend has eloquently made, is that this is a school that has gone through transition quite dramatically in recent years to move from an 11 to 14 high school to an 11 to 16 all through school. It has had significant internal remodelling to ensure that it could provide a full curriculum, bearing in mind that a high school does not provide GCSE options, whereas an upper school or an all through school would. So in other words, the science labs and the other specialist facilities have been adapted within the school. What I suggest to you is two things, if I may, sir. First of all, we provide to you as evidence the 2021 SCAP submission, so the school's capacity submission to the DfE, which clearly documents the school as having a 900 capacity. And to make Ms. Townsend's point again, the 995 is a legacy issue which relates to the 2019 SCAP submission, so 2 years out of date. And when we track that back to evidence coming out of the school, the evidence coming out of the school to underpin that was actually submitted in 2017. So it was mid-flight of its transition programme. The other point I was going to make is, if you are visiting the area, you are very welcome to visit, I'm sure, Humphrey Perkins School if you wish to have a look at the site and how the spaces within the school are being occupied. We're not seeking to hide anything from anyone in this particular circumstance.
Okay, thank you. Anything, Mr. Hunter? I mean, in terms of the SCAP data, Mr. Atterbury, you're offering that for Humphrey Perkins?
Yes, we can do, yes.
Okay, any thoughts, Mr. Hunter?
Ultimately, sir, it won't actually make a difference to our arguments, because even if the school does have a physical capacity of 900, certainly that's a significant deviation from the funding agreement of the school, which states 1,106 pupils age 11 to 16. So it's somehow between 2018 and currently it's lost the ability to accommodate 206 pupils. Even if that is the case, and we have yet to see the evidence to suggest that, there are alternatives. There's two issues here. The first is that Humphrey Perkins School is operating under its admission number in every year group. Leicestershire County Council are relying on a considerable number of pupils coming forward from developments to take that school over capacity, and even then it is not significantly over capacity. And then the additional point, which again, as I've alluded to, is that there is another school which we have evidence serves Sileby, and as of the previous academic year was operating with 555 surplus places.
Okay, we'll come to Reek Academy in a moment. I think just in terms of your first point about the planned development, I think that might just be helpful. The County Council have provided a table showing the sort of 222 pupil places that are coming from various developments in the area. It says it includes this development, this appeal scheme. Although I looked at the table on page 5 of the County Council's response to my questions, and I couldn't see this appeal site listed. And I also note that it includes Peasel Farm, which has an application at the moment, the 175. So presumably, Ms. Townsend, that is obviously pending, like we were discussing for Highgate.
Yes, sir.
If you could help me with it, where does the 222 exclude this appeal site?
Just bear with me 1 second, please, sir. I'm just frantically looking for it. It's in the report. If you just bear with me 1 second, please, I'll just pull that up. Sorry.
That's okay.
Apologies, my computer keeps going on to mute. Could I ask you to repeat, sir, which page you were making reference to?
Yes, sorry, yes, it's page 4 and 5 of the County Council's response to my question. So this is the document dated the 16th of March.
Okay, thank you.
And it was the 222.
Could you give me the paragraph number?
Yes, if you go to page 4, at the bottom of page 4, 2.7. It's about it gives the table for Humphrey Perkins.
Oh, here it is. I've got it. It's this one, Dave. Apologies for that. Yes, I've got that.
That's okay. So yes, it's understanding where the 222. It includes Peasel Farm, which is a pending application, and it doesn't appear to include this appeal site. Have I got that right?
Yes, that's correct, sir. That's correct.
So in theory, one could
substitute the other one, couldn't it?
I guess so. I suppose the yield from this development
would be slightly lower.
Yeah, but in theory, if Peasel Farm got permission, then and this scheme got permission, you'd obviously be.
It's been addition, yes.
In addition, so 222. So it's not quite right that it says 222 includes this development.
No,
it doesn't. And it obviously includes the Peasel Farm outline application, which obviously remains undetermined. So obviously that if we took off Peasel, it would go down to 192.
Yes.
But obviously you then need to, as you say, factor in the yield from this development, which would take it up again.
Yes.
Okay. Thank you. Any comments on the figures, Mr. Hunter, that I've just set out?
I not specifically on the figures, apart from obviously all of those developments have to come forward, and there are options. This is another fundamental issue, that there are options for Sileby residents as to which school they go to. I would like to just, if I may, direct you to Leicestershire County Council's policy, CD 6.34.
Is this the planning obligations policy?
Yes, the planning obligations policy.
Yeah, go on.
So paragraph 42 of that policy states the capacity of the catchment school in terms of primary provision and the nearest school in terms of secondary provision.
Yes. Okay. I think this is your Reek Academy points. That I think
like to make the point that that the nearest school to the development is actually Reek Academy, and there are links to Sileby in every year group for that school.
And you base that on your FOI request or the FOI
request, and also as Leicestershire County Council have corroborated many times, it is actually the considered provision for sixth form already, so there is that identified link between that school specifically and Sileby.
Okay, thank you. So Mr. Atterbury, you have your hand raised. I assume you'd like to comment on the relevance of Greek Academy.
Yes, so I was just going on to say, if you look at 42A in its entirety, it goes on to say, and any other school within a 3-mile walking route of the development. The key point here is that Reek Valley Academy may be slightly nearer than Humphrey Perkins. I don't think we dispute that. The geography is quite evident there. However, there is not an available walking route between Cossington, or this development, should I say, and Reek Valley Academy. In actual fact, quite the opposite. There's very little of a walking route. There's no footways along the Cossington Road at all. And there's quite a restricted Midland Mainline Railway bridge to cross as well, with no footpath over it. In contrast, there is an available walking route all the way between this application site and Humphrey Perkins, which is just on the cusp of the 3-mile limit, depending on where you would live within the application site. Historically, just to add to that, though, Humphrey Perkins is the feeder secondary school to all of the primary schools in the area. So should these pupils attend a school within Sileby or Cossington, we've had that conversation. There's no progression links in terms of education with the Reek Valley Academy. Okay,
so does Reek Academy represent a reasonable alternative then?
No, not at all. No.
Okay.
It serves a completely different area just to the north of Leicester.
Okay,
sorry, if I may just add to that.
Yes, go on. Yeah.
The only way Reek Valley figures in the conversation is that it becomes the nearest post-16 provider, because obviously Humphrey Perkins doesn't cover the post-16 age group. Okay,
and presumably, is there a walking distance issue for sixth form level, or
no, because sixth formers generally tend to travel. I'd be impressed to see a sixth former walk into school. That they would not walk 3 miles to a school. They tend to.
Thank you, Mr. Atterbury.
Sorry, if I just may add to that, schools transport policy doesn't apply to sixth form provision either. It only relates to 11-16.
Okay, thank you. Mr. Tucker, I think you have your hand raised. And you're on mute, Mr. Tucker, I think.
Those make my points far more compelling, I find, when I put them on mute. So just really 2 points. I had intended to raise 1 point, which was going to be a query through you to the county council. But the second point, so I'll raise first, which is Mr. Atterbury's last point. The Education Act 1996 does identify that the trigger point at which, if the county council can't, or the LEA can't provide a place for a pupil within 3 miles, then beyond that 3-mile trigger, they are required to provide transport. That is absolutely 100% not a figure which is used in terms of the propensity of anybody to walk. You'll be aware, sir, of a vast amount of guidance out there. Indeed, we provide significant evidence of it within the transportation assessment as to likely propensity. So you should not work on the assumption, sir, that merely because something is just within or just beyond a 3-mile walking distance, that therefore means that there will be a propensity for anybody to walk to school. And there's some recent appeals in relation to that, should we need to provide that. It's a point that's quite obvious, to be blunt. The second, whilst accepting that's the threshold the government places in the 1996 Act, the second point is the explanation for the difference between the 900 and the 995 figure that's been given by the County Council this afternoon is that that Humphrey Perkins changed from being an 11 to 14 entry level school to an 11 to 16 level school. According to its website, that took place 10 years ago. It took place in 2012, not in the last 2 years. So I'm a little perplexed by that. So if that's being suggested, that's the reason for the difference. I'm struggling to see how that correlates with the data that appears out there. And I just seek some clarification from the County Council in that regard.
Okay, thank you. Mr. Atterbury, do you want to come back on those 2 points?
Yes, there's 2 points there. I don't think we should be taking a view about the propensity of pupils to walk to school or not walk to school. The fact is as Mr. Tucker rightly pointed out, the law is the law, and that's what the DfE state as a threshold for entitlement to receive transport assistance. Nevertheless, it's still a fact that some parents wouldn't walk around the corner; they'd rather jump in the car. So we could have a long discussion about that one. In terms of the age range situation, yes, the age range change was approved in 2012, but age range changes do not happen overnight. It actually impacts the admission number of a school, and then a number of years then follow where the larger admission number entering at year 7 then moves through the school. When actually in terms of an 11 to 16, it's a smaller admission number then moves through the school. So yes, you are correct in stating it was approved in 2012, but in reality, the transition period would extend up to 5 years to get stability back in the school.
Okay, thank you. Anything else to say on secondary school points? The contribution source obviously is to go towards improvement works at Humphrey Perkins or the nearest school. So again, sort of similar question I raised earlier about the scope and likelihood of that being spent. But I don't know if there's a point that Ms. Tanton wants to make first in response to Mr. Atterbury.
Yes, sir. It was just with regards to the available number of places at the school, because as Mr. Tucker has outlined, the change was undertaken in 2012. In 2018, that was when the funding agreement for the academy was signed, which detailed that the school had available places in terms of 1,106 places. So if it strikes me that if it was necessary, if there was forecast that the number of places was required in the long term to be that higher number, that would have been maintained. But it does seem odd that the school would reduce its size so considerably within a few years, and then on that basis planning obligations sought from developments that would directly be served by that school, especially when, as Leicestershire County Council's own policy states, that the first school they would look at would be the closest, and in this case the closest school has a significant number of surplus places, already has links to Sileby, and is the school for sixth form pupils. So you would almost argue that would be a better school in terms of continuity of education.
Okay, I know Councillor Jones has a hand raised. I don't know if Councillor Jones wants to make a point in relation to this discussion that we're just having.
Yes, please. You haven't mentioned Rawlings Academy. Traditionally, pupils from Sileby went to Humphrey Perkins and then on to Rawlings Academy. And I know that a number of pupils do go to Rawlings at the age of 11. So why hasn't Rawlings Academy been mentioned?
Okay, thank you. Maybe a question Mr. Ashby could answer in the first.
Yeah, I mean, I can answer it. I won't have the detail to it, but Rawlings Academy is slightly further afield from this development than either Humphrey Perkins or Reek Valley as an 11 to 16 provider. It's also a school that's at capacity, and I'm sure Ms Townsend, if we chose to do so, could provide the information to validate that position. It is a fact that also that Rawlings is a post-16 provider. Again, it's operating at capacity, but again, it's slightly further away from this development than Reek Valley would be as a post-16 provider. What I would say, sorry, just to come back to the point, if I may.
Just wonder whether Councillor Jones wanted anything.
Yeah, sorry.
But the other point is that there obviously is a regular bus service from Sileby to Quorn, where Rawlings is, and there's a regular bus service from Sileby to Barrow, where Humphrey Perkins is. There isn't a bus service from Sileby towards Reek Valley in Syston.
Okay, so if you are suggesting, Councillor Jones, that as a second consideration after Humphrey Perkins, we place Rawlings on the list rather than Reek Valley, then we're happy to look at that. But I think you'll find that the demands for places at Rawlings are far more acute than those at Humphrey Perkins or Reek Valley.
So could you tell me how many pupils from Sileby currently go to Reek Valley?
We could do that if it's classed as material evidence to validate our point.
I think it probably is. You're putting forward that Reek Valley would be the second choice. And if it currently
no, absolutely, I'm not. No, Mr. Hunter is. I'm not.
All right.
Yes.
What I would ask, sir, if I may, is if it's helpful to show pupil movements at secondary age from Cossington and Sileby communities to the various schools in the locality, we can probably do that. Take a little bit of work to postcode them, but we can do it.
I wasn't sure if we had that for Reek Valley anyway, and not because there was an FOI request for Reek Valley to show people from a Sileby postcode who attend that school. So we already have that information, and I don't know if or how much benefit it would be to see. Okay,
that's fair enough. Just to come back to the other point Mr. Hunter made, then, if I may, obviously myself and Ms Townsend have everyone else at a bit of a disadvantage here, and I do apologise for that, in so much that we've been both closely involved with the remodelling of the schools over the years, and indeed it's still in progress. And all I can do is repeat my offer, really, to let you visit the school and have a look around for yourself and talk to the leaders in the Academy Trust to get their view on the transition challenges that they faced in recent years.
Okay, thank you. Anything else? Yes, that's the only other question I had was, yes, so the contribution towards secondary education would go towards improving, remodelling or enhancing Humphrey Perkins or another school in the vicinity. Is it a similar kind of point that you made in terms of primary contribution from the county council perspective, that it would depend on what scope there was for expansion at that particular point in time, and whether it would be at Humphrey Perkins or somewhere else? Is that right, Ms. Townsend?
There would be scope there, sir. Yes, I've had discussions with the Lionheart Academy Trust that run Humphrey Perkins, and they've got aspirations for the campus. It was originally taken over by an academy because it was actually required improvement. So it's had quite a few challenges as a site over the years. It's certainly turning a corner, and they're doing lots of work to improve the campus, and we've done a lot of work with them on improving certain things and access and joint funding arrangements. And so in terms of proposals of what we want to do to master plan that site, yes, that funding would certainly be very helpful to contribute towards that. Okay.
Any comments, Mr. Hunter, on?
I would like to just make a comment on the councillor's comments about Rawlings Academy. Just generally, this was actually covered in the appellant's original proof, CD 10.23. We discussed all of the schools that serve Sileby. One of them is certainly Rawlings Academy, and there are quite a significant number of pupils. We don't have the specific numbers, but we can demonstrate from the heat maps that there are a significant number of pupils from Sileby attending that school. The wider point to say about that is that Rawlins Academy, and whilst I recognise that we are using, we're using the most recent projections in the public domain that are available to us that have been verified by the DFE, but Rawlins Academy is in its own secondary school planning area with Humphrey Perkins School, and on the basis of the SCAP projections that are in the public domain, that planning area is never forecast to go over capacity.
And your point, Mr. Hunter, on
that there is forecast to be surplus capacity at the in the planning area. In planning,
taking the two schools into account.
Yes.
Combined. Yeah. Okay. Mr. Atterbury. You're on mute, Mr. Atterbury.
Amount of development in Quorn, which is the village in which Rawlins is located. I know the school extremely well. It is also a very constrained site, so should we seek to expand Rawlins, I can confidently say there'd be no potential to do that.
Okay, thank you. Mr. Hunter?
I'd just like to challenge the point of Mr. Atterbury. The Freedom of Information request demonstrates that there is a link with Reek Valley Academy in every year group, and therefore there is a direct link between Sileby and school.
I think you'll find that if we did an in and out catchment analysis of any school in Leicestershire, you will see movement to all sorts of areas. I think what we're saying here, and I think you'd have to agree, Mr. Hunter, is that the predominant and historical links for the Cossington and Sileby area are not to Reek Valley. I don't think that's a point that you could disagree with.
No, I certainly do not disagree with that. Where I think we disagree is whether there has been sufficient evidence to demonstrate that planning obligations are necessary and that harm would arise if they were not secured. That's always been the fundamental issue.
Okay. If there's nothing else on secondary, I'd be happy to move on to cover special educational needs contribution. And the argument here, Mr. Hunter, is basically that you're saying it's not necessary because the development would generate less than one pupil per primary and secondary level. But I suppose my question to you is that not a point that could be an argument that could be made to any development of a certain size, up to 250 units or thereabouts, and is that a reasonable argument to make?
Absolutely, sir. To give the full background. So, Leicestershire County Council has stated that there will be 0.62 primary school age children.
Yeah.
In the development with special education needs. So that essentially that means that there is a 62% chance that there will be one child of primary school age with SEN on the development site. And our argument has always been that we do not believe that is sufficient evidence to justify planning obligations, as it cannot be conclusively established that harm would arise if this planning obligation was not provided. The exact same argument is in place for secondary SEN, where Leicestershire County Council has stated there will be 0.68 children on the development of secondary school age with SEN. That means a 68% chance that there will only be one child of secondary school age with SEN on the development. And again, I just do not believe that that's sufficient evidence to justify planning obligations. Now, if I may refer you to paragraph 6.11 of the Statement of Common Ground. That states, if you have that available.
Yeah, 1 moment. Yeah.
So that states it is agreed between the parties that children having specialist SEND, which is special education needs and disabilities, are most likely to attend specialist provision outside of the immediate area, whereas those with an education, health and care plan and less complex diagnosis of SEND may need to attend a mainstream school with SEND support. Now, the government states that the percentage of pupils with an education and healthcare plan who are in mainstream schools has increased from 48.7% to 50.4% in 2021, which means there's more than half of pupils with SEN are accommodated sort of in mainstream schools. So that means that there's more than a 50% chance that SEN will be accommodated in mainstream schools, which further reduces the likelihood that a child with specific SEN requiring specific provision will be located on this site. Now, there's many examples that I can provide that demonstrate how other education authorities have approached this matter, and it's exactly how you have previously suggested, in that there is usually a threshold of developments that you look at before SEN contributions are requested. The highest that I've seen, which I believe I referenced in the appellant's proof, is Essex County Council, which starts at 2,000. There's many examples of developments that would wait until around sort of 500. The average would be 200 plus, but certainly below the threshold of this development, because ultimately you need to be able to demonstrate that there is a likelihood that there is a strong likelihood, because when you're working on percentages, it's very difficult to be able to assess whether harm will actually arise, and it's simply a case of fulfilling the tests of SILREG 122.
And there is a threshold here, but you're saying it's obviously not as high as.
I don't even know if there is a threshold.
I'll ask the county council on that.
Leicestershire.
Okay, thank you. Anything else, Mr. Hunter? Or should I turn to Mr. Ashbury?
Please feel free to open in.
Yeah, Mr. Ashbury, your
thank you, sir. There are a couple of points to make there. I mean, the first one was the obvious point that you stated earlier, that all of these fractions of a percentages for developments all over Leicestershire start to add up and add then to a significant burden for the county council to cater for SEND pupils. I think in some respects, Mr. Hunter's right what he said about SEND pupils. Also, though, I don't think he fully understands the requirements of SEND pupils so much that they have changed since the introduction of the 2015 SEND Code of Practice. If I could give you the example in Leicestershire, and we have been commended for our approach to SEND provision by the DFE, we have been embarking over the last 3 years on a significant programme of SEND development, and the predominant driver for that has been a dramatic increase in numbers of SEND pupils, both at a local level and a national level, and that's something that's well documented. And if we start to get into the detail of this, there are 3 levels of provision in Leicestershire. In actual fact, it's probably 4. Those pupils with the most complex and profound needs will most certainly attend schools outside of the area, so what we call special schools, and those would form into 2 categories, either those managed by the local authority, of which there are 8, or those which are in the independent sector, which obviously come at a very high cost. When we talk about pupils being educated with the HCPs Education, Health and Care Plans in mainstream schools, there are 2 ways that can be done. Firstly, by integration of a pupil with, if you like, higher functioning needs, such that they could hold their own with support in a mainstream class. But as is most often the case now in Leicestershire, we will be adding resource bases or units in terms of their old terminology to mainstream schools, so they will add a significant increased cost. And again, a point that I'm sure Mr. Hunter will not disagree with, that the cost of providing a special school place is significantly greater than that for a mainstream school. So I think again, you need to better understand the Leicestershire position. What I would say is that the incident rate of SEND need, both in Leicestershire and certainly in Charnwood, has crept above the threshold set out within our planning obligations policy. So if we were to reopen this conversation and look in detail and try to do something which is more particular to the district, then I would expect, and I'm quite confident in this, that the claim coming forward would probably be greater than it is at the moment.
And what is the threshold for the size of developments where you seek special educational needs?
Pick that up, Sharon.
Sorry, sir, it's 100 dwellings. Is the threshold?
Yes, I thought I'd seen that, but thank you for clarifying.
Yeah.
Okay, thank you. Mr. Tucker, you have your hand raised.
I do, sir. Just to draw your attention to two parts of guidance which are of relevance when you come to consider this issue. The first of which arises from the County Council's obligations document at paragraph 49, which I'll come back to in just a moment. The second of which is Annex N for November, of the Planning Inspectorate guidance, and in particular section N for November 3, under the title Justifying the Need for the Planning Obligation. And the off-cited paragraph N 3.3.3, which tells you what you're required to identify, and that includes details of existing facilities or infrastructure, etc. So that tells you what you're meant to identify, and you're meant to identify how the money's being identified and how the money's going to be spent, and the methodology for calculating it. If you look at paragraph 49, as to what exactly paragraph 49 says, it says where there's a development over 100 dwellings, not that triggers a payment, but that triggers an assessment of the need to secure additional accommodation for pupils. And then it goes on to say any contributions will be pooled to improve or enhance facilities at the most appropriate school or unit. This may not always be the closest facility to the development, and then explains why. And then says, in determining the need, so the job that you're doing now, sir, for these types of contributions, appropriate evidence and data will be provided by the County Council in relation to the number of special schools and ERP places and SEN units available across the county, and the current and forecast demand for these types of pupil places. And then it tells you how you assess the yield. So it's not just a matter of saying there's the yield and therefore that triggers a requirement. There's the yield, and then you're being told that you have to have information in place of an assessment to prove why there is a need for funding. And so that's consistent with paragraph N.3.3, and that's the yardstick against which you need to assess the County Council's request against before you, sir. Because if it fails against that yardstick, sir, then it fails against the requirements of policy.
And does the appellant have a view on that, whether it's been done or not?
Well, that's a matter for Mr. Hunter rather than me, sir. So I'm simply drawing your attention to the guidance.
Okay, thank you. Okay, well, Mr. Ashbury wants to come back.
Yes, I was just going to say we'll happily demonstrate where the special schools are in Leicester, where the resource bases are, and what their current capacity levels are. There's no reason to hide that, and the evidence will simply confirm that those locations are significantly oversubscribed, such that the County Council at the moment has a heavy dependence on the independent sector, something that we're trying to avoid because it doesn't represent good value for money. But nevertheless, we are where we are with that. But if that information is helpful to the inquiry, then we can provide that.
Okay, Mr. Tucker's got his hand raised again.
Yes, sir. This is the point at which I become all lawyerly, I'm afraid. Because there are rules in this particular set of processes. The County Council's approach to providing you with information hasn't exactly been on all fours with those four corners with those rules, for reasons that I don't need to explain and I won't go into. But the idea that we come to the obligation session at which the County Council has it pointed out that there's a huge hole in its justification for this particular contribution, and then says, well, if it's helpful, we can provide the information, isn't good enough, I'm afraid. If the County Council is seeking money from the private sector in accordance with its own published guidance and PIN's published guidance, which it should have known about an awfully long period of time ago, and that requires additional work from my client to undertake behind the scenes to address it, to assess it, if necessary to rebut it, then, sir, I do warn the County Council as to what the consequences might be, because this information should have been before you already. All I have done is drawn attention to information that Mr. Atterbury and his team should know about already and should have known about before the exchange of evidence. So I've not said anything one way or the other in terms of the information and the justification, but Mr. Atterbury's response demonstrates to you, sir, that there is a gaping evidential hole in the information before you to justify this request.
Okay, thank you, Mr. Tucker. Mr. Atterbury, is there a gap in your evidence?
No, not at all, sir. We've provided
what I've got.
We've provided sufficient information to validate the places, and bearing in mind we've been engaged with Mr. Hunter now for a couple of months. If it was felt by the applicant that there was a gap, then surely it would have been raised with us and we'd have happily provided that information. As I said earlier, we've got no reason to withhold information.
Okay, but in terms of Mr. Tucker's point about providing further information, is that something you still wish to do, or are you with the evidence that you've provided already?
If you think it has a material benefit to this inquiry, then we'll do it. That's all I'm saying. If Mr. Tucker's saying it's not needed, we'll make a judgment, or you should make a judgment as the inspector on the information you have before you, then fine. I mean, we'll go with that. We have the information to hand. There's nothing that we need to do with that.
Okay. And when Mr. Tucker talked about the consequences of that, I assume you understand, the points he was making there about extra time and costs.
Yeah, it's very polite of him to remind us of the consequences. But if that help validates our case for the request, then so be it. We're prepared to spend that time and effort doing so.
Okay. Thank you, Mr. Thomas. You also have your hand raised.
Yes, thank you, sir. Just to make the additional point that since this appeal was lodged, there's been quite a lot of discussions with the appellant about various matters, as you're aware of, and also you, sir, asked for some further information, which we've provided to you. So the point I'm making was, if there was an issue around the evidence around this particular issue, then I think that probably would have been raised already. So I completely understand the point that Mr. Tucker's raising, but if there were concerns about the quality of information being submitted, that would have been done so already, I'd have thought.
Okay. I mean, I will make the general point that the roundtable discussion should be the opportunity to discuss the evidence that is already being tabled, and whilst there's always a potential scope for providing clarification and additional information, we do have to obviously draw a line somewhere as to whether or not further information is appropriate. And I'll reflect on what's been said about this, and if I feel there's a need for more information, then I will say so. Obviously, the parties are aware of the implications. They've been set out and discussed. So, in terms of the contribution that's being sought, I don't know if the County Council wanted to say anything about the fact that the 100 dwellings only triggers an assessment rather than a contribution. Mr. Atterbury or...
No, I don't think... Sorry, Sharon, go on.
Sorry, I think I've misunderstood that. The claim is for an allocation.
Yes, there's a sum of money being sought, isn't there?
Yes, there is. Yes.
Yeah. I think we've made our point that we believe there is a reason for the claim. So okay. in that respect, you can take it as read that the assessment's been done and the need is there. Okay. Fine, and that contribution would go towards providing facilities at Ashmount School in Loughborough or another facility. It really depends what the EHCP states as a primary need. Ashmount School is a school for those with PMLD, so profound moderate learning difficulties. If, for example, there's children coming out of this development that have communication and interaction needs or social, emotional, mental health issues, then they'd clearly go to a different type of school. Wouldn't be one in the locality, it'd be somewhere else. But so we'd have to look very carefully at what the HCP stated. Okay. At the time. All we can say at this stage is that if a child generally travels to a special school, normally it would be an area special school and one that caters for PMLD. And yes, and presumably does Ashmount, you mentioned about it, obviously schools being oversubscribed, is Ashmount one of those schools then? Absolutely. As Sharon Townsend will know, we are actually engaged in conversation with the school at the moment about expanding it. It has a significant shortfall on places at the moment. It was a school that was built for 125. I think at the moment it's operating with about 180 and all sorts of buildings added around the perimeter of the site. Okay. Anything, Mr. Hunter, you want to say about Ashmount or the contribution itself?
Just in terms of the contribution itself, is that I still cannot reconcile the amount of money being requested with the likelihood of potential harm coming forward, because we're dealing with fractions, and I think as stated, many other educational authorities would deal with larger developments in order to guarantee that as far as possible that there would be at least one child, so that you can and then place that child, rather than dealing with percentages, which means that. And ultimately, I have a lot of respect for the work that Leicestershire do in this regard, but the question is whether the burden of proof has been met to demonstrate that money needs to be coming from the appellant, and I can't reconcile the two things.
Okay, thank you, Mr. Atterbury. Any final comments?
Yes, please, sir. It comes back to the point I made earlier that the cost of providing SEND places, as Mr. Hunter will readily recognise, is significantly higher than those for mainstream schools. In that context, it would clearly be inappropriate for the local authority to seek to round up numbers, because it would be taking more money away from developers than we are actually entitled to. We don't wish to do that. We just need to secure enough funds to create those specialist places. So that's why we work off fractions, and it's a system that works for us.
Okay, thank you. Anything else to say on special educational needs, or can we move on to the final point of early years? And just to understand the County Council's latest position on this, that there was previously a request, I think, for 14 places, and now I think there's only a 10-place request. Is that right, Ms. Townsend?
Yes, that's correct. It's reduced.
And that's been based on assessing other developments that are coming forward and provision.
Yes, provision.
I think the concern, Mr. Hunter, that you have is whether or not the number of places being sought sort of overlaps with the Pease Hill scheme. Is that primarily the concern the appellant has?
Firstly, I think it's worth just pointing out if you go to the again, if I may refer you to the statement of common ground between the appellant and Leicestershire, paragraph 6.10, it is stated, it is agreed between the parties that all early years provision in the area is provided by the private, voluntary and independent sector. Now, what Leicestershire what I have not seen is Leicestershire stating where the funding is going to be spent. I think there's a fundamental issue with a county council passing planning obligation funding to private early years providers, because as far as I'm aware, unless they have procurement rules in place, it would be in breach of procurement rules, and that because ultimately there would need to be a tender process with regards to this. It's problematic, without a doubt, to pass public money onto private business. And also, there's just the fundamental issue of spare capacity in the area, and there's certainly no guarantee that the provision would go over capacity. And ultimately, it's the culmination of this that demonstrates that the burden of proof for education planning obligations has not been satisfactorily met, and thus the appellants have not been able to agree to date. Ultimately, I don't know whether, and it hasn't been presented to me as to whether the existing private entities that offer early years places could expand themselves. And in terms of being able to offer additional places, it may be as simple as hiring an extra member of staff, and then so that the head count between children and staff members is correct, and that may be sufficient to add capacity to the area. It simply hasn't been demonstrated clearly that the pupils from the early years pupils from this development cannot be accommodated, and two, that it wouldn't simply, as a continuation of what is currently happening, be picked up by the private sector.
Okay, thank you, Mr. Hunter. Mr. Atterbury, you have your hand raised.
Yes, thank you, sir. We have demonstrated to Mr. Hunter that there are currently 5 childcare providers in the area, and when we look at their current capacity and take-up of places, there are 4 surplus places. So in that respect, when we net those off a claim for 14 places from this applicant's site, then 10 places are needed. So that's a justification, and Mr. Hunter has had the detail of that, and I think it's also been shared with yourself. In terms of would the County Council put money into the private voluntary sector, then absolutely not. That would be anti-competitive to seek to favour one provider above another. We certainly would not be in that position. But again, as Mr. Hunter will know, the DFE now encourages that preschool provision is now developed on school sites, certainly for new schools and those having significant expansions. That is our preferred approach. So in securing the funds, what we would seek to do would be to engage in a conversation with the school that had capacity to expand and add a preschool. They obviously see that as advantageous to their position because it allows them to work with pupils, 2, 3 and 4 year olds at a younger age, which eases their progression then into mainstream schools. So I think we've very clearly set out our case for those places. We've said we've included Barnard's Drive. There was mention of Pease Hill Farm. We've only included one phase of Pease Hill Farm. We haven't included the later ones. So I think there's probably not much more to say to that. I would close though by simply saying this. It's again, when we request 10 places, it's a maximum claim that we perceive may arise from this development. We are happy to keep a conversation going in that respect. And if we feel or see, should I say rather than feel, that if a private provider within the area expands their capacity, or indeed a new provider moves into the area, bearing in mind the other developments that are taking place, then it would remove our need to make a claim. I come back to my opening points right at the beginning of this conversation is the County Council is not a profit-making organisation. We will only take funds which we feel are necessary to mitigate the impact of a particular development. Thank you.
Okay, thank you. Mr. Hunter?
You're on mute.
Apologies. I don't have it in front of me, but is there a mechanism in the Section 106 agreement where if, for example, the Pease Hill Farm development does get a positive determination and, as has been requested against that development, places for early years provision, that is a request, that somehow the figures would be netted off this development? It's just and again, apologies, I don't have the document in front of me, but is it as currently drafted just a full contribution, or is there a mechanism currently?
There is. Sorry, just to clarify that, the first 170 homes of Pease Hill Farm have been included in our calculations. So in terms of a mechanism, yes, there is. It is a general mechanism that covers all of our contributions, not only early years, but SEND, primary and secondary, and transport. If we don't need them, we will not claim them, or indeed, if we have claimed them and don't need them, we'll return the funding.
Okay. I mean, this point about the Section 106, we may need to look at after the lunch break in terms of the precise wording. But does that help, Mr. Hunter?
Well, I've just been informed that there is no specifics in the Section 106, so it does seem that Leicestershire County Council is requesting 100% of the, are requesting a full contribution without the opportunity for other developments coming forward. So my initial thought was that as this is this development has yet to receive positive determination, Pease Hill Farm has yet to receive positive determination, that it would make sense that if they were both feeding into the early years provision, that there should be equity between the two developments. Clearly there isn't. There's been requests from Leicestershire County Council towards both developments, but ultimately I still don't feel like the evidence for this requirement on the basis that 100% of the provision is being provided by the private sector has been met to be able to justify planning obligations under SILREG 122.
Okay, thank you, Mr. Hunter. You have your hand raised as well. Did you want to add?
So did you mean Mr. Tucker, sir?
Sorry, Mr. Tucker. Sorry.
Sorry, I've been called worse, sir.
Okay, Mr.
People
Tucker.
usually get my surname wrong by accident, deliberately rather than by accident. So in relation to the point of the 106, that is a point that we can revisit within the discussion, although there is a repayment mechanism. It's not quite the way that is suggested by Mr. Hunter. The real point, sir, is that every application has to be determined on its merits at the time it's being considered. And therefore, if Pease Hill comes after this appeal is allowed, if this appeal is allowed, then it will be for the County Council to react to that at that stage. And that's simply how matters are approached in relation to issues of this nature. But it really is a matter that we can discuss later on when we talk about the 106. But I just wanted to pick up another point, which is the test that you need to apply. The test you need to apply, sir, is whether or not the contributions being sought by the authority are necessary, not whether they are the maximum that may arise, which were Mr. Atterbury's words. That's not the test. You're not creating a safety net in all eventualities. You are identifying what is likely to arise and what is therefore necessary to be mitigated. That's what the guidance says, which I drew attention to at the very outset. So I'm afraid it's the wrong test, but that's a point I'll come back to in submission, sir.
Okay, thank you, Mr. Tucker. Mr. Thomas, you have your hand raised, and Mr. Atterbury as well. But Mr. Thomas, first of all.
Yeah, thank you. No, but based upon just responding to that last point, first of all, the evidence that's been submitted by the County Council is that the 10 places is the latest information that we have to say what is required. I think the point that Mr. Atterbury was making was that in the event that circumstances change locally, such as another local private provider comes into the area, then there's obviously the money wouldn't be required, and we would happily either not collect the money or repay any money spent. In terms of the Section 106 agreement itself, happy that we'd pick that up a little bit later. What I would say is that the clauses of the agreement have been drafted by the council's solicitors. So if there are material changes that the appellant is suggesting, or that you yourself, sir, are saying that may be appropriate, then we would need to just discuss that with the County Council's solicitors. But we can perhaps pick that up a little bit later and see if anything emerges in that respect.
Okay, thank you, Mr. Thomas. And then Mr. Atterbury.
Thank you, sir. I was just going to clarify the language. What we're not saying here is this is a maximum demand. It is based on an assessment of the evidence that we have before us. And at the moment, we have a number of applications, including Pease Hill Farm and Cossington Road, Sileby. So we can only use our best endeavours to work with the information before us. I don't need to add further to that. Thank you, sir.
Okay. And just to clarify one final thing, the Pease Hill scheme, which is not yet determined, there's been a request for early years places or contribution there. Does that overlap with this appeal scheme, Ms. Townsend, or anybody else from the County Council? I think is a point that Mr. Hunter raises in his most recent comments, is that Pease Hill does the same. Sorry, Mr. Asprey.
It's probably a question that's best put to the planning authority. They can comment more eloquently than we can on the timescales for that development.
Okay.
All we can see is it's in the system at the moment as a requirement for early years places, and I can't comment any further than that. I do apologise.
No, I appreciate the County Council. Sorry, the Borough Council have the ultimate sort of planning responsibility, but obviously the County Council have made requests on this scheme and the Pease Hill scheme. So I'm just trying to understand whether there's an element of double counting or not.
No, not double counting. I think what we're talking about here is should there be a consideration of first past the post, which is why we're happy to keep a conversation open about the requirement for early years places. Clearly, if the Pease Hill Farm application disappears or changes in terms of its housing quota, then this will have an impact to this particular application, and I say we're happy to consider that.
Okay. Anything anybody else wants to add on this point or early years generally? Okay, thank you. I think then that covers. Oh, Mr. Asprey.
Sorry, that was a legacy. I do apologise.
Okay, thank you. So that covers all the contributions then. And I say, if there's anything we need to pick up in the 106 session after lunch, we will do that. Are there any other relevant matters? Anything else anybody wants to raise under the final item on the agenda? Anything from the appellant, Mr. Hunter?
No, I think everything's been covered from my perspective. Thank you very much.
Okay, and anything from the County Council, Mr. Atterbury, or anyone else?
Not from me, thank you, sir.
Okay,
Not for me, thank you.
thank you. So I think obviously there's a few things that we came up during that session, the two sessions, which was the data for the Highgate School will be circulated, both to the appellant, but also a copy for me as well, please. That can go via the Borough Council if needed, or directly to my case officer, whichever way. And then Mr. Hunter will provide a note on that information. There's also a preference made to the SCAP data for Humphrey Perkins, which I think was agreed that could be provided. I don't know if Mr. Hunter may want to comment on that as well.
Ultimately, sir, I don't feel that it makes a difference to our case, because not only is Humphrey, without go over evidence that's been stated, not only does Humphrey Perkins have capacity in the year group at present, but there is alternative provision available in the area to be able to accommodate the pupils from this development. It really is that.
Okay.
But sir, as Mr. Hunter's lawyer, in the event that it raises something that we need to comment upon, then thank you for the opportunity, sir. Thank you.
Okay, well, I'm happy to have that SCAP data as well then. I think any other information, I know we talked a bit about specialist schools, further information. I think I'll reflect on that, and if there is anything else I think I need, I will let parties know. But otherwise, that will leave it there. Thank you all for your contributions. I know that probably took longer than anticipated, but it has been very helpful and has covered a lot of ground. So thank you for that. And if there is any further agreed positions between the parties between now and the end of the inquiry, would be helpful to see set out. So we'll take a lunch break now and then come back to talk about conditions and obligations. I assume the County Council will obviously be around for that, so at least some of the County Council will be staying for that session. Mr. Thomas, I assume, and others.
Yes, sir. Sorry, can I just clarify the intention in terms of timings and what the programme is for this afternoon, please?
Yeah, so I was intending to take a lunch break of about an hour, so we might come back about 2:10 to talk through the section 106 and the conditions. I don't have a particular preference as to which way around we do them, but I assume the County Council will need to be present for both potentially. So
yeah.
And then hopefully we'll be done within sort of an hour and a half or thereabouts. So if we're happy with that, sort of to break for an hour and come back. I'd see Mr. Richards has his hand raised.
Yes, so just to tell you that the inquiry documents now appear on the website.
Okay, thank
There's
you.
an inquiry documents list just above the core documents list.
Okay, thank you.
And version 2 of the programme, i.e. our updated programme, is now also on the inquiry webpage.
Lovely. Thank you, Mr. Richards. Okay, then. So if there's anything, unless there's anything from anybody else, we'll have an hour's lunch break and we'll come back at 2:10. Thank you.
Thank you.
Thank you.
Thank you, sir. Thank you, Mr. Hunter.
Thank you.
Hello everyone, it's 2:10 and the inquiry is resumed. So are there any procedural points before we move on to the obligations and conditions roundtable?
Not for our part, sir, thank you.
No, nothing from us, thank you, sir.
Okay, thank you. So I was going to propose we look at the section 106 first, partly because there are sort of possibly things that follow on from this morning's discussions on education matters. So we'll do that first and then come to the conditions list. So just to understand in terms of who's participating, Mr. Richards from the council, you've got presumably officers.
Yes, I've got Mr. Gould and I've got Mrs. Knott.
Okay.
And as Mr. Tucker has been rightly saying, matters of law and construction are for us and planning judgment are for others.
Okay, fine, thank you. And Mr. Tucker, I see Mr. Wakefield is on screen, is he?
Yes, sir. Yes, sir. You've got Mr. Wakefield on screen, who has been the draftsman of the 106 from our side of things. You'll see from the tagline, which appears on his screen, which is fantastic. I need to work out how to do that. That he is with Shakespeare Martineau, where I think unless you pin him, sir, it simply says legal advice for life and B, which I read as legal advice for life and beyond, which is a little optimistic, but apparently it's for life and business.
Okay.
So it will be Mr. Wakefield that deals with the 106 in terms of the technicalities of construction and draftsmanship, etc. There is an issue with regard to healthcare provision, which plainly Mr. Hunter's also provided his view on in writing, which Mr. Hunter can expand upon if you particularly needed us to, sir, but you have it our position in writing anyway, and
Okay.
he will be available to help in relation to education matters in any event.
Yes, yes, I see Mr. Hunter. Mr. Hunter's still obviously around for that
Yes, sir.
purpose. Yeah, thank you. And then from the county council, I see Mr. Thomas and Ms. Townsend are still there, as well as Mr. Atterbury. So if the county council need to come in at any point, obviously just let me know, or I'll ask you to come in if I need you to.
That's fine. Thank you, sir.
Thank you. And as with the sessions this morning, it's a roundtable discussion, so I'll direct my questions and discussions. If anybody wants to make a point, then there's the raise hand function, which worked pretty well this morning. So we'll continue to do that. Fine. If there's no other introductions, I should say also that interested parties listening to the call can obviously come in at any point as well. If they wish to, they can raise their hand. That would be good. Thank you. So if we start with the section 106, the obligations in that document, and we're looking at the latest version dated the 22nd of March 2022, which is now on the appeal website as inquiry document 5, I believe. So thank you for putting that up promptly. So we'll run through the document. I obviously circulated some points before the inquiry opened, which I think have been addressed, but we'll come to those. And there's a few other things I wanted to raise, obviously including healthcare. First of all, just in terms of the contributions themselves, just as a general point, some of them require them to be paid sort of staggered over a period of time based on first occupation, 25% occupation, so on. There are some that require the payment to be made in full prior to first occupation. So I think this applies to like the libraries, civic amenity, travel packs, and bus passes. I just wanted to know, obviously the figures are based on the total number of dwellings. So by the time of first occupation, will we know how many dwellings are to be provided overall? And is there any way of kind of ensuring that is kind of established? I don't know if Mr. Wakefield perhaps first of all might have a view on that.
Sir, my anticipation is that ultimately this will come forward as one reserved matters application, assuming the appeal is allowed, and therefore by the time we get to first occupation, there'll be full planning permission in place for the whole of the site, and therefore it should be possible to calculate any contribution that's done on a pro rata basis at that time.
Okay. Thank you. Anybody have anything else to add, or does Mr. Richards, that sound reasonable from the council's point of view?
Yes, sir. I don't think we've seen anything anywhere in the evidence that suggests there's going to be, for example, two developers on site with two different developers with running, outlets sequentially or simultaneously or anything like that. I don't think we've seen any evidence of that. And a scheme of this size ought to be a single reserved matters application.
Okay, and certainly, yes, by the time first occupation occurs, it will be clear how many dwellings will be delivered in total.
Absolutely.
I mean, we haven't had to discuss build out rates and that sort of thing at this inquiry, but let's say it's about 160. That's 3 to 4 years worth of build out rate.
Mm-hmm. Okay. Yeah. Okay. Thank you. Anything else, Mr. Thomas? You have your hand raised.
Thank you, sir. Now, the only additional point I was going to make in relation to your comment about the civic amenities and libraries contributions is that the amounts are so small that typically we do ask for them up front just because of for administrative purposes and monitoring. It just makes it far simpler to do it that way.
Okay. Thank you. Thank you. I just wanted to clarify that particular point about payment. So that's helpful from everyone. Thank you. And then I note we go through, we'll skip through the definitions, although we may come back to them and then go to the various clauses. I note that clause 4.2 has been sort of expanded to cover the sort of what's known as the blue pencil clause, which for the benefit of those less familiar, it basically allows me to come to a view as to whether or not some obligations should be included or not. And so I, based on the discussions and the evidence that I've had been given, that I would come to a view on each and every obligation and decide whether or not they met the tests. So thank you for sort of expanding that to clarify my role there. I think the only thing I had is it's a typo or a grammatical issue, is whether or not in the final sentence whether there's a preposition missing after clause 5, because it says any part of clause 5, the second schedule and the third schedule. I just wondered whether it needed an of or a that kind of
Thank you, sir. I think an of would be appropriate. So thank you for your eyes on that.
That's okay. I think it also appears twice in that sentence because clause 5 appears twice in that sentence. So it's the same as the same thing needed. It's but thank you. And then I think that was all I had to say on the clauses. I think I was happy with all of that. And then going into the schedules, schedule 1, I've been given a copy of the plan which shows the land. Basically, it's exactly the same as the appeal site, apart from the access onto the road, and that's obviously just to make sure it's tied to the right landowner.
Absolutely, sir. And the access is within the public highway, so it's to avoid having to split that in terms of defining it as application land and obligation land for the sake of argument or anything of that magnitude. It's all within the single ownership.
Fine, thank you. And then just skipping through then to the second schedule and paragraphs 2.3 and 2.5, I think it is. I just wondered here whether or not there needs to be some kind of deadline by which the owner should be writing to the borough council, because the previous 2 paragraphs talk about not occupying the development or a certain amount of development until a scheme has been agreed. But then paragraph 2.3 talks about writing to the borough council, inviting them to inspect the open space and for the borough council to confirm in writing. I can't see anywhere in that paragraph 2.3 any kind of timescale for that. There is, if I read it like that, it could be, it could happen at any point in the future. Have I read that right, Mr. Wakefield? Or?
Well, I mean, the point, so with 2.3, and its interrelationship with the preceding paragraphs, there's a cut-off point by which the open space needs to have been designed by way of the scheme and then subsequently laid out. So that's the stick, as it were, for my client to make sure they get the open space done and laid out in an acceptable fashion. The point with 2.3 is that once they've laid it out at any point up to the occupation of 85%, they can write to the council. You're at the final certificate stage, and that's where 2.5 kicks in. So there's flexibility within that.
Okay.
But there's a 12-month period of maintenance that runs from whenever the provisional certificate is issued.
Okay. So as long as those paragraphs are all read together, then they should all make sense in terms of timing. Okay. Anything anybody else wants to say on that? Fine. Thank you just for clarifying that. And I think it was the paragraph 2.6 of, so in the same schedule. Is there a typo there where it says paragraph 26 of this schedule? Should that be 2.6?
I suspect there is a typographical error there, sir. I will.
I don't think there is a paragraph.
It will be 2.5. That should be paragraph 2.5, actually, sir. It's the invitation pursuant to the preceding paragraph.
Yes. Okay. Yes, that makes sense. Okay. Thank you. Thank you. So yes, so that was the sort of general comments. I think just whilst we're in the second schedule, the affordable housing contribution, obviously that's the council set out the reasons for that. The appellant doesn't dispute the provision, and so I don't have anything to say on that. And likewise with the on-site public open space, that's been set out by the council, and again, I know the appellant doesn't dispute that either. I don't have anything more to say. Obviously, there's been some change with the outdoor sports aspect. This has changed. It was in previous version I saw. It was there was a combination of outdoor sports allotments and indoor sports. And I noticed that's now been split into outdoor sports and allotments, and indoor sports have been dropped altogether. Is that on the basis that the indoor sports and on the basis that the Borough Council doesn't seek that requirement anymore? Is that right, Mr. Richards?
Yeah, that's right, sir. And you'll have read that in our SIL compliance document.
Yeah. Okay.
It was in originally. Work went on behind the scenes, discussing whether it could be justified under the SIL regs. Yeah. Agreement was reached that it couldn't, and so we took it out.
Okay. And then the reason for separating out the outdoor sports and allotments, is there a reason for why they've been sort of split into separate contributions now?
Sir, if I can jump in there, the rationale for doing that is because obviously they're directed to slightly different purposes within a wider ambit of open space, green infrastructure. Following discussions with my opposite number at the Borough Council, it seemed to make sense to split them out, to allow them to be dealt with individually, and therefore the blue pencil clause applies to both halves, as it were, of that contribution, rather than dealing with them holistically.
Okay. And the justification for those, Mr. Richards, is that set out in the compliance statement? But
I believe it is, sir. But Mr. Gould will confirm.
Mm-hmm. Just what Mr. White that those are sourced, but obviously not indoor sport. Mr. Gould is there.
No, Mr. Gould's just sent me a WhatsApp and which says yes.
Sorry. Okay.
Sir, if I can perhaps seek to direct you there, the council's still compliance statement deals with open space contributions at paragraph 3.9 and onwards. I would comment that it refers in paragraph 3.9 to the council's open spaces team having confirmed a number of projects to which the contribution could fund within the vicinity of the site. Having asked the solicitor representing the Borough Council on a number of occasions, I've yet to see that list of sites, and you'll appreciate that the Section 106 is quite broad in terms of where those contributions can be directed.
Yes, I did notice that the. Sorry, do you want to finish what you were going to say, Mr. Wakefield?
Well, only insofar, I mean, from my client's perspective, my client is content to pay the contributions as drafted. At the same time, if the council were to offer a list of a project or specific projects, I would have no issue with narrowing that focus further.
Yes, I was going to raise the point that I think it's in Schedule 4, the fourth schedule, about the Borough Council's covenant. It says that to use the outdoor sports contribution and the allotment contribution in a manner consistent with the recommendations of the Charnwood Indoor Built Facilities Strategy. And I did have a question as to what relevance the Indoor Built Facilities Strategy had to outdoor sports and allotments. So I think there is probably a need to for the Borough Council to clarify what projects it's seeking to fund through those two contributions, particularly in terms of the outdoor sports, but also the allotments.
Yes, sir.
Mr. Richards.
We'll do that, unless anybody in my team puts their camera on now and says there is already such a list. We will provide you and Mr. Wakefield with a list so that they can go into the obligation as you require. Thank you.
I think, yes, if there isn't any immediate response, that would be helpful. I think the only thing I've been able to refer to is the council's open space officer, their consultation response back in April last year, where they set out the requirements for the different elements. And I don't think that goes into any detail either. So I think it would be helpful to know what it is the council has in mind for the outdoor sports facilities. And also allotments to in terms of where that requirement comes from.
Yeah, so we will produce a list of the potential recipients of the Section 106 monies under this head. So rather like with education, you name a school, we will seek to provide named projects, or at least projects in Sileby or wherever it is.
Thank you. It would also be helpful to know how the figures have been derived as well. I think just on what basis have X amount of money been requested for outdoor sports and allotments as well, please.
Righto, sir.
Thank you. Anything else anybody wants to say on outdoor sports facilities or allotments? I think so. Yes, I think because of where we're at in the relatively early stage of the inquiry still, I'm happy if the parties are happy to to receive some further clarification on this. I assume, Mr. Tucker, you're happy with me receiving that?
I am, sir. So you asked about whether anybody else had a comment. I can see
yes.
Councillor Astle's hand is up. I don't know if that helps, sir.
Yes, thank you. Thanks for that prompt. Yes, Councillor Astle, you had your hand raised.
Yes, I did. We've identified in our neighbourhood plan for community facilities appraisal, and also in the Borough Council's open spaces strategy, that we have a shortfall in outdoor pitches. At the moment, we're struggling with pitch provision for junior football, but we're also undertaking significant works on the Memorial Park, which is where the juniors actually are based with their football, but also we're looking at much more diverse use of that, and we would welcome any provision of funding to go towards that type of facility which is in the village and of benefit for the village, rather than it being allocated to somewhere on the other side of the river that's inaccessible during flooding. So I wonder if you'd be able to perhaps consider that, and maybe on your visit to the village have a look at the facilities on the park.
So, certainly happy to look at the facilities. Is that Memorial Park?
Yes, it's the Memorial Park. There's a car park there. You'll see the football pitches are marked out. There's also skateboard provision. We've just undergone a master plan, a concept master plan for the park. We have moving play equipment and putting in much more diverse playing facilities, as well as provision there for biodiversity. So it's quite a significant development.
Thank you. And did you want to say anything about allotments in Sileby as well? Yeah,
we do have some allotment provision, which has been coming forward from the Pease Hill development, which is that's actually going underway at the moment, and that provision joins on to the cemetery. So we're waiting for those monies to be released by the Borough Council, but obviously it will all need setting up there. So there is actually an identified allotment expansion site in the village.
Okay, so I think thank you for that. That's very helpful, Councillor Astor. I think if the Borough Council can provide me with their some the additional information for both the outdoor sports and allotments, and it sounds like they've got, certainly from what you've said, Councillor Astor, they've got things that they can refer to.
Yeah, I think some of the issue is that the open spaces officer had left. There'd been a replacement and the old officer's back. So they may have a clearer view of what's going on in Sileby, and they have done a lot of work looking at that.
Okay.
That's very useful, sir, and I'm quite sure that my team have heard what Councillor Astor's been saying.
Okay. Thank you. Thank you. So I think, yes, if the clarification can be had then on both outdoor sports and allotments, and say just clarify whether or not reference to the indoor built facilities strategy is intended or not. I think, and if it should refer to a different document or strategy, then that obviously needs to be spelt out.
I can confirm it's not a typographical error, sir. But I think whether the council wish to refer to a different document on the back of this discussion certainly open to that conversation.
Yeah. Thank you.
It may be a legacy as to when the indoor sports provision was in the 106, but we'll have a look at it. I mean, it might be unusually that outdoor sport is in a document called indoor sport, but we'll see.
I think there is a copy of that document in the core documents library, but I've not been given any references to
it's core document 6.33, I believe.
Yeah.
So, and having looked at it, I as I say, it's not a typographical error. That is the document the Borough Council instructed should be included. But I think the point is well made that perhaps it's not the right document.
Okay, fine. Well, I think there's some work to be done on those two contributions then, please. Thank you. So the other contribution within the second schedule, which we haven't covered, is healthcare. And this one is obviously contested by the appellants. And I suppose from the council's point of view, obviously the council have referred to the clinical commissioning group, the CCG's response about the need for a contribution. So presumably, Mr. Richards, does the council rely on the CCG request for its purposes?
Yes, it does, sir. And the nub of the issue seems to be that the CCG request says, which is core document 4.23, I think.
Yes.
Right at the very end says, these practices are already experiencing capacity issues in relation to their premises and would need to make improvements to enable them to register new patients resultant of this development prior to that registration.
Yes.
And in reply to that, both in the planning proof, Ms. Smedley's planning proof at paragraph 7.50, and in appendix 3, the education and healthcare note at paragraph 12.11, the appellants say in terms, well, the information we've got from websites, and they produce a page shot, both of these facilities are accepting new patients, still accepting new patients, and therefore they can't be said to be at capacity. Now, we rely on what the clinical commissioning group tell us, and what they told us is that they are experiencing capacity issues and would need to make improvements to enable them to register new patients resultant of this development. Now, those are not mutually incompatible positions. And the appellant's response doesn't gainsay what the CG have said would be the position as a result of this development. And that's the evidential issue that you will have to determine. I'm not sure that we can assist you much either way.
Okay, well, I see there's some hands raised from Mr. Hunter as well as two of the parish councillors. So I've asked maybe Mr. Hunter, first of all, to come in, please.
Thank you, sir. Yes, just to confirm, I have checked this morning, and both of the GP practices that will directly serve this development are still open for new patients. Nothing has changed in the interim between the production of our evidence and today. Clearly, as is outlined, our evidence for the against the primary healthcare contribution is detailed in the appellant's proof, CD 10.23, in paragraph 12 onwards. I would be more than happy to sort of summarise that for you and pick up some of those points now, unless you're happy that that it's already all included and that you have the detail that you need.
Well, I've certainly read what you put there, Mr. Hunter, and in essence, you're saying, well, not just the fact that the practices are still open for new patients, but you also suggest that funding arrangements, there are separate funding arrangements for GP expansion. So it's a broader point that you're making. Is that right?
It is, yes. So essentially, capacity at NHS practices is not calculated in the same way as schools, for example. And this is because it's not about capacity, but about patient utilisation. So if an NHS practice opens for an hour longer every day or opens at weekends, its capacity grows. What is evident is that there's a statutory process to go through if an NHS practice is full. And as stated, neither of the NHS practices that directly serve this development, that's the Banks Surgery or Highgate Medical Centre, have gone through this process. Now, an additional point to make is that West Leicestershire Clinical Commissioning Group have assumed that there will be 2.42 people per dwelling in the new housing in Sileby, and have asked for planning obligations for 100% of the people likely to be resident within the houses. And that's according to their average of 2.42 people. Now, from the information that we've ascertained, the postcode area of LE127 Sileby equates to 17,608 persons registered with a GP in 8,002 dwellings. That's an average of 2.2 people per dwelling, which is less than what the CCG is requesting, therefore making their request excessive. And the other point is that it's also very likely that the population that will be living on this development will in many cases not change GP practice, or equally in many cases will select a GP practice on the basis of the free choice, which is enshrined in the NHS Constitution, and not necessarily proximity. The vast majority of NHS practices have inflated roles, as Parliament reported. That's detailed in our document.
Mm-hmm.
GP patients have a free choice of practices to attend. That is per the NHS Constitution. Without the commissioning board closing a GP practice to new patients, the chosen practice must accept the patient. And if there is no demonstrable deficit that would be made worse by new development, then the contribution is not necessary to make it acceptable in planning terms, and it therefore fails the tests of SILREG 122.
Okay.
The very last point that I'd like to make. The NHS is a national service funded from taxation. So the duty to provide all that is necessary rests with the Secretary of State and the NHS England, and thus the necessity requirement in SIL Regulation 122 is simply not met. The impact on local services would be from a subset of the total population living on this site. And this is because many of the residents would be expected to have moved from elsewhere in the borough and would already be accessing local services. However, NHS England, as to the CCG, is again requesting funding from 100% of the expected population of the site, which is excessive and not SIL Reg 122 compliant.
Okay, thank you, Mr. Hunter. So, are you in effect saying that Section 106 money should never be used for healthcare purposes? Then, based on your argument.
Yes, I am saying that fundamentally, and I think that the NHS Constitution backs that up. I think that there may be an argument to make if the GP surgeries are completely full and closed to new patients, and then perhaps. But I would need to do further work to ascertain whether that is the case. But I do believe that because it's a national service funded from taxation, and the NHS and essentially the NHS is supposed to fund 100% of that, I don't believe that it should be on developers to fund that aspect.
So in that case, if you're correct, then why the CCG and others in other parts of the country, from my experience, ask for a contribution?
Well, I believe that they're doing so in order to provide additional funding and because the opportunity is there. In my personal experience, is every time that I've made these arguments, they have been upheld, and I think that the main issue is that this just simply isn't challenged enough.
Okay. I will come to both councillors in a second. I don't know if the Borough Council first of all wants to respond.
Well, just 2 points, I think. So the first point is that any number of statutory bodies are tasked with providing infrastructure.
Okay.
And then secondly, I'm aware, of course, where both the Secretary of State on appeal and inspectors in their own right have drawn a distinction between revenue funding to pay, for example, doctors and nurses, and infrastructure funding to pay for bricks and mortar. And it's the latter that has, in my experience, if the evidence is there, it invariably been found to be SIL compliant. I appreciate there is an example, there is an argument to be had over revenue funding, and for example, for periods of catch-up between when the NHS funding model kicks in to pay for additional staff. But this is not this case. There's no request for that in this case. This is simply about bricks and mortar infrastructure to increase capacity at local GP surgeries.
Okay. Thank you, Mr. Richards. Mr. Tucker, I will ask for you to come in first, because I think we just want to finish off this point before I go to the councillors.
Thank you, sir. Sorry, I was just taking my hand down. So it's very, very tempting for me to start the diatribe as to why it is that Section 106 doesn't provide a power for general taxation, and to tell you all about the Article 2 of the Bill of Rights, etc. I'm not going to go down that route. You'll be disappointed to hear, sir. Two things, really. The first of which is I agree with Mr. Richards that where there are land use consequences which are which are fairly and directly related to the development, then in principle those land use consequences can be mitigated by virtue of an off-site contribution, however that arises. Deficit in allotments, issues in terms of road capacity, issues in terms of bus services, etc. So where there are direct land use consequences, then that can arise. There is an interface in relation to primary health care, and as to whether or not that really is something for general taxation. But I don't ask you to focus on that in this case, sir. I asked you to focus on our principal argument, which is it's just not warranted on the evidence. And that's really our fundamental point before you. I should say, notwithstanding it tells against me in relation to the secondary argument, i.e. the temptation to go down the route of the Bill of Rights and tell you why it is that Section 106 isn't a general taxation power, that there has been recent litigation in relation to the issue of funding for a health centre, and that's the HFAG case. So it's Crown R on the application of HFAG against Buckinghamshire Council. That's 2022 EWHC 523, and I'll make sure a copy's lodged with the inquiry. So that's R on the application of HFAG against Buckinghamshire, 2022 EWHC 523. He didn't grapple with the principal point that I'd love to run one day, and that my witness has just drawn your attention to, i.e. it's an unconstitutional argument about the powers within Section 106. But nonetheless, it did uphold the payment of a planning obligation in relation to a health centre, which then supports Mr. Richards. And that's really coming on to say that there is recent authority which is supportive of Mr. Richards' proposition in that regard. Okay. So the issue is our primary case, so it's not warranted on the evidence before you. And that's the one I'd invite you to focus upon.
Thank you, Mr. Tucker. If I could turn then to Councillor Astill, first of all, to come in with her comments, please.
Thank you. In the past, Section 106 monies have been spent on infrastructure at both of the health centres in the village, the Bank Centre and Highgate Medical Practice. The problem with any expansion, physical expansion with those sites, is that it would involve building on the car park if they wanted to put more consulting rooms. Both of the sites are very constrained. And what we find ourselves in, unfortunately, is this position that we're getting a large number of houses being built here, but the actual infrastructure is remaining the same and the number of practitioners remaining the same. Now, I understand the argument that this can't be a revenue funding, but the problem is that when you've got a limited area to actually see people in, it has to be open more, which is the provision of more practitioners, not necessarily the provision of more space. When you mentioned that the option for people is to go to other medical practices, you look at Syston, at Barrow-upon-Soar, at Mount Sorrel, at Quorn, at Woodhouse Eve, all these local practices. They have also been subject to very large housing developments are absolutely stretched. So in reality, there isn't really a lot of choice. If you are struggling, you either have to wait a long time to see the GP or stay where you originally came from, which isn't always in this vicinity. A lot of people are still, retaining where they were moved from some distance away. So from our perspective as residents in the community, the 106 monies aren't solving the issues of accessibility to healthcare, and it's an ongoing problem. Now, how you look at that and deal with that, obviously, I don't know, but that's on the ground and our experience.
Thank you. That's helpful to hear that. And Councillor Jones wants to also come in as well, please.
Yeah. Just really reiterating what Councillor Astell has just said, and with an illustration that my soon-to-be daughter-in-law has registered with the bank's practice, and it took her over a year to do that till the space became available for her. And there's lots of issues that I know it's hearsay, but issues that people can't get appointments. Obviously, the pandemic has made the way practices work slightly different, but I'm assuming that at some point they will get back to more face-to-face consultations, and there is that issue with trying to get appointments. So even if they were able to expand bricks and mortar wise, which is probably more difficult with the bank surgery because it is constrained by the fact it's got Sileby Brook on one side of it and a house on the other side and a very small car park. There is nowhere to expand. The issue of opening hours presumably relies on there being more doctors and nurses being able to cover those opening hours. So it is an issue, and I don't know the legal ins and outs of the why it should be 106 money and why it shouldn't be 106 money, but it's always been an issue. I myself at the practice in Barrow-on-Soar, because at the time we moved to Sileby there was no space for us in the local health centres. So that's what I wanted to say.
Thank you, Councillor Jones. It's helpful to have your perspective as well. I don't know if the appellant wants to respond to the points made by the councillors or the council. Mr. Hunter, anything you want to say?
No, sir. I think that the sort of main points have been made. I would just like to reconfirm that absolutely our main argument is that the evidence for the contributions is simply not met the standard necessary for 106 under the SIL regulations. I do reference a particular planning appeal that took place in Balderton in Nottinghamshire that's actually referenced in our proof of evidence, which deals with this exact issue, that the CCG was stating that the local GP surgeries were unable to accommodate new patients. All of them were open to new patients, and the inspector recognised that, and that was reflected in the decision.
Okay.
And again, that's in the appellant's proof, CD 10.23, details of that.
Okay. But nothing else I want to pick up on the kind of local experience, the difficulty finding appointments or getting registered.
I can't speak to that. I have not specifically known the area. All I am aware is that, as stated, as of this morning, both surgeries are open and are advertising for new patients.
Okay. Thank you. Mr. Richards, anything the council wants to say on the local experience?
I don't think we can usefully add anything else, sir.
Okay, thank you. So the contribution, if it were to be taken forward, so it would make a contribution towards providing additional capacity at either Highgate and or Banks surgery, and I don't think it would apply anywhere else, would it? Looking at the the wording of the 106. So it's solely for the purposes of providing additional capacity at those two surgeries. And if it's not paid, if it's not spent within 5 years, then it would be paid back. So
Yes, that's right.
that's the essence of it. Okay, fine. I think, thank you for all that. It's helpful to have gone through that in some detail. Thank you. So if there's nothing else to say on healthcare, then I think we'll turn to the third schedule, which is the county council obligations. Obviously, we've discussed this morning in detail the various education contributions, and I don't think there's anything more to say apart from the early years one, where there was this issue about whether or not it needed to be tied to another development. I don't know if any thought or discussions taken place on that since then, Mr. Wakefield or anyone else.
I've not had any further discussions with any representative of the county council in that regard. So,
okay.
And I am mindful that paragraph 5 of the fifth schedule is again quite broad in terms of the scope for where that contribution can be spent, broader certainly than any of the other education contributions. I don't know if anybody from the county council wants to jump in or to propose a narrower form of wording for that.
Mr. Tucker, first of all.
Yeah, just to add, sir, Mr. Wayfield's right that there's been no further discussion behind the scenes, and our principal position remains exactly that Mr. Hunter explained to you, sir, at the end, that whilst you could have a complex mechanism within the 106 which allows account to be taken as to which one comes forward first, unless it's the case that phase 3 is imminently to be consented, which doesn't look likely. In those circumstances, it's first come, first served, and we anticipate that this scheme is likely to be determined one way or the other well in advance of phase 3. But if that's not the position, then others will tell us, sir.
Okay. Anything from the county council?
Hi, sorry, I've only caught part of that, I'm afraid, just at the end part. Just can you please remind me of the question, please, sir?
It was whether or not the 106 needs to be more specific about the early years contribution, and whether how that might be spent and potentially linked to any contribution that the Peace Hill scheme might provide.
Yeah, my understanding is I think my colleagues would be happy to look at that. Are you suggesting a revised form of wording or potential? Sorry.
I think no. Sorry, Mr. Thomas. I didn't mean to.
Should I repeat my point, sir? Would that be helpful?
Yeah, please.
Yeah, our position is that the suggestion that we had a complex mechanism within the 106 to take account of what happens were phase 3 of the other scheme to come forward prior to the determination of this application, and then to have an issue as to which one was commenced first is unnecessary, and that the usual approach, which was described as first come, first served, is applicable in this case, and that's the most straightforward way forward. So unless there's a good reason to deviate from that, which we haven't seen that yet, but the county may have other information, then that seems to be the best way forward in this case. So unless the other scheme was imminently about to be consented, then that scheme, when it's to be determined, would have to take account of the grant of consent in this case if this appeal is allowed.
So, in other words, is it best left as it is? Is that what you're essentially
exactly
saying?
That's the conventional approach, and that therefore this becomes a commitment that would be taken account of at the time of the determination of the next application.
Okay. Any comments, Mr. Thomas?
I'm inclined to agree with that approach, actually. That seems to make sense to me.
Is it fair to say all the education contributions do have a clawback sort of position, so if they're not spent?
Yeah, exactly.
Then
sorry, sir. That was the paragraph we spoke about earlier on this morning. Whether or not that is fit for purpose in its entirety, I've had a quick look at that myself, and I think it probably is. But the appellant or the representatives may have a different view on that.
So the paragraph 16, the sort of the monitoring
Yeah.
paragraph.
Yeah.
But if there's any tweaks needed to that, then there is still scope for that to be discussed. Thank you. Then I think the other contributions in the county council contributions.
Sir, sorry to
Yes.
interrupt. I'm conscious that Mr. Atterbury and Councillor, I'm sorry, I can't see the surname, have both got their hands up on my screen.
Thank you. I'm sorry. I've scrolled down on my page and I've missed that they both had hands up. So thank you for pointing that out. Councillor Astle, your hand was up first.
Thank you. I just wanted to point out that you keep referring to phase 3. This is a totally separate application for Pease Hill. It was never put forward as 3 phases. There was one application, there was a second application meant for revision, and this application is a total standalone application. It was never intended. So I think when you're referring to it as phases, it's somewhat misleading, particularly as it's still yet to be determined. So
Okay.
I hope that's okay.
I mean, I'm not intending to refer to it in any particular way. I'll be happy just to refer to it as the undetermined Pease Hill application.
Thank you.
And so, as am I, and I was only picking up the phase 3 reference because that was the description by the county council. So that's the only reason why I was doing. I was keeping the convention. Certainly, I'm not suggesting it was ever planned as a phase 3.
Okay, fine. Thank you. And Mr. Atterbury.
Thank you, sir. I was simply going to concur with the view expressed about section 5, and Mr. Tucker helpfully qualified that at the end of his statement. So I'm happy with what's been proposed. Thank you.
Okay, thank you for clarifying. Okay, so then just the other contributions, county council related ones, the libraries and civic amenities, I have no comments on those. And then there's a number of bus stop and shelter contributions, and I know that the bus stop improvement contribution has been amended to refer to raised curbs rather than double providing for a bus flag, a bus pole. So thank you for that. And I also noticed there's a travel pack contribution, which, if I'm understanding that correctly, that's not the same as a travel plan, is it? I think, Mr. Thomas.
No, sir, that's absolutely right. The travel pack is effectively a contribution to promote sustainable travel measures, and so could include sort of information and ways of encouraging residents to travel by sustainable means, as opposed to a travel plan, which is a very different document in terms of how residents or employees, in the case of employment development, will be discouraged from travelling by single occupancy car journeys, that sort of thing.
Okay, in which case I probably made an error in my comments on one of the conditions, which refers to travel plans, because I think there is no obligation relating to travel plan. I think I've got travel pack and travel plan muddled up.
Yeah, it's definitely a pack in this case.
Yeah, separate thing. Okay, well we'll come to that condition in a moment then and deal with that. Thank you. I think then that is everything else. That's everything I wanted to raise on the 106. Unless there's anything else anybody else wants to bring to my attention, Mr. Wakefield.
So very, very quickly, having re-looked at the wording of clause 4.2, I think it, rather than an of, I think it should be, because it's not a clause of a schedule, it's technically a paragraph. I think it should be clause 5 and or the second schedule and or the third schedule.
Okay.
For the purpose, because actually it's clause 5 immediately below 4.2, which effectively gives operative effect to the contents of the schedules.
Okay. Yes. That's fine. I think whichever preposition works.
That's fine. So I just didn't want to not flag the point just in case you're expecting an of in the fullness of time. So
I think it was more to just so that the sentence when read made more sense.
No, that's fine. I think it was intended as a list, so I think the preposition could probably survive without. But I think I'm sure and or will not be controversial with the two councils.
Okay. Well, if it is, let me know and
indeed
have a debate over that. Thank you. So just in terms of next steps with the 106, the obviously Borough Council has a task to provide me with information on the allotments and outdoor sports facilities contributions. I don't think there's anything else that I am seeking from the discussions we've just had. So obviously, I think probably in terms of next steps, presumably a final draft of this 106 needs to be produced and circulated that everyone's happy with. Ordinarily, we'd be at the end of an inquiry at this stage when we're talking about the 106 and be needing to agree dates for execution. But I suppose, given that we may not be concluding the inquiry until late April, I guess it's possible that we may be able to have the 106 finalised and signed off before we close. But I'll take views on that. Mr. Wakefield, or
certainly, sir. I mean, I suppose the advantage of leaving the Section 106 agreement uncompleted until the conclusion of the inquiry is obviously if anything further comes out in evidence that subsequently needs to be addressed, because as you say, typically this would be sort of the penultimate session of an inquiry rather than, on day 2.
Yeah.
There's some scope for amendment, but if we can agree the points that we've discussed today, I see no reason why we can't circulate an engrossment and have it signed by the parties in the intervening period, and then hold the signed copies in case we need to make a manuscript amendment at that point before completing it. That would, I think, allow us to be, we can certainly issue a completed version very close to the culmination of the inquiry, rather than a couple of weeks hence, for the sake of argument.
Okay. Anything anyone wants to add from the council or anybody else? No. I think yes. I mean, it's sensible not to sort of rush and get it signed and sealed and everything before we get to those final sessions. And equally, I am happy to allow some time afterwards for that to sort of take place. I think the main thing is probably just to get everything sorted in terms of the drafting and everything else before we close, and then if there's a short period of time needed just to sort of execute the document, then so be it. Councillor Jones, you've got your hand raised.
Yeah, it's not to do with 106 money, but I did hear you just say the word before we close. Can we, as a parish council, make a request when you do your site visit that you, if you can manage to be around the site roughly at school closing time in Cossington, that you will see the amount of traffic that is generated, or if you can manage to be at any of the Sileby junctions that are at the choke points around from 4 o'clock onwards, just so you get an idea of the amount of traffic that A is going down Cossington Road and into Cossington, and B that come out of the main junctions from the High Street, King Street, Mount Sorrel Lane, Barrow Road junctions. Okay. We would really appreciate that.
Thank you. The site visit's intended. I'm planning to do that next Tuesday.
Yeah.
And I hadn't sort of finalised my exact timings yet, so it's helpful to have that. And when I say close of the inquiry, I mean I was referring to sort of towards the end of April, where we have our final session. That's when I would close, but the site visit would be before that. That's the plan anyway. But we can discuss on Friday any arrangements for that. But thank you for making that point.
Can I just say, if you're obviously going to be getting off the train and be on Sileby Station, from there you will land up at one of the main choke points in the village, so you'll come out onto King Street.
Okay, fine. Thank you. Well, I'll work out my logistics, and thank you for adding that point. Okay, so I think that's probably everything to be said on the 106. Are we happy to leave things there and turn to the conditions?
Thank you, sir. With your leave, I'll be excused and leave the conditions to others.
Okay, thank you, Mr. Wakefield, for your contributions.
Yes, and if I could invite Mr. Gould to turn his camera on, he'll be leading on this, sir.
Okay, thank you.
And so from my perspective, if I can ask Miss Smedley to turn her camera on as well, please.
Okay.
Thank you.
Thank you. Thank you both. So yes, I have the most up-to-date schedule of conditions dated yesterday, and in a similar fashion to the 106 given where we're at in the inquiry, there's still scope for further iterations if needed. But hopefully we are sort of getting towards a sort of reasonable final list. As a overriding point, there's a number of pre-commencement conditions which obviously don't need written approval from the appellant because we're dealing with an outline application. However, it will be necessary to justify them. I think in most cases with the conditions, I understand why they're pre-commencement. So it can't, like construction management plan or tree protection. I don't think that needs to be said. It's all goes without saying. But there may be one or two where I seek comments as to why it's a pre-commencement condition. Mr. Thomas, you have your hand raised.
Thank you, sir. I was just going to ask the question whether or not you required anybody from the County Council to be involved in this part of the session. I wouldn't normally expect us to be. The only thing I could think is if there's any transport conditions you might want some help with, although I haven't been involved in the drafting of any of those. So
no. I think if you were happy to stay for the next sort of half an hour or so, Mr. Thomas, it would be helpful just in case there was anything that you could help with or feedback to colleagues on. But certainly if your colleagues, Mr. Atterbury and Ms. Townsend, wish to leave, then I have no problems with them doing so. And obviously, thank you to them both for their contributions today.
Thank you. That's very helpful. Thank you.
Thanks. OK, so just to run through the conditions, so we'll take them one at a time. So the first condition deals with reserve matters. That's been shortened to 18 months, I think, hasn't it, from the standard period to sort of bring the development forward faster. Is that correct? Mr. Gould? I think you're on mute.
Yes, sir, that's my understanding as well. If I may, could I make a suggestion? Could the I haven't got the up-to-date list for conditions. Could that be shared on the screen and run through? Is that acceptable?
Yes, if someone has that. I mean, I have it, but if I do that, I probably can't see you all. I don't know how it would work, but if somebody else can.
I'm sure a member of my team can email Mr. Gould directly the most up-to-date list of conditions, if that helps.
I do have it, but I just want to make sure I've got the right one.
I've just emailed that across to you, Mr. Gould.
Yeah, I've just received it, so I will retract my request. I've got this in front of me and I can read through that. Thank you.
Okay, thank you. So yeah, so there's slight feedback. That's you, Mr. Gould, or me, or not. Anyway, that sounds all right now, so that's okay. So yeah, so the condition one, it was 18 months for reserve matters. That's been sort of sped up from the standard wording, and I think that's been in order to bring the housing forward faster. Is that correct?
Sir, if I may, that's exactly the reason. Obviously, the 5-year situation. So we are looking to advance the site and bring it forward.
Okay, thank you. And then condition 2 and the draft condition that follows it deals with the reserve matters. Thank you for responding to my point about the circulation routes and them needing to be dealt with separately because of access being not a reserve matter. So I can see the changes that have been made there, and the wording is I think similar to the wording I suggested, if not the same. So I've got nothing to say unless anybody has anything they want to say on those conditions.
No, sir.
Thank you. And then condition 3, which is about plans, there's a clarification that the proposed site access junction is revision A, which I think we established on the first day, but it's helpful to see that there. And then we have a new condition that talks about the development being in broad accordance with the design principles of the illustrative master plan revision A, particularly with regard to the siting of the residential development. So again, this was raised on the first day about trying to secure in broad terms where the development should go if it were to be approved. So both parties happy with that wording and that principle? Mr. Goulden from the council.
Yes, sir.
Okay. Thank you. Okay. I think normally we'd have come to conditions after we've heard all the landscape evidence, but obviously that will may well sort of be reflected when we hear from the landscape witnesses. Mr. Tucker, you got your hand raised.
Yes, I appreciate that the parties are happy with those conditions. If you required something that was, how can I put it, a bit of a blunter tool which identified developable area, open space area, then obviously there is still the opportunity for us to prepare a plan which simply takes those elements from the illustrative master plan and identifies those, so that you could include that no development, for the avoidance of doubt, no development shall take place on however that area is marked to the south of the built on area, to make entirely sure of that. But I'm happy to leave that with you if you think that will be a good or a useful thing, simply to make matters certain for those who are involved in reserved matters who may not be part of this inquiry.
So essentially be a copy of the master plan, but sort of zoned out to be built developments, open space.
Exactly.
Yeah. Okay. Also, I'll give that some thought. Thank you for suggesting it. I suppose it's whether or not it's how much that is needed or not. But I'll have a think. And does the council have a view on that at all?
No, sir. The idea is to separate the built development from the open space area. The idea is not to open up an argument at reserved matters. For example, the leap is shown in the middle of the open space and you've got it at one end of it.
Yes. Yes, I suppose it's whether broad accordance is flexible enough. But yes, it's about the general location of development.
Yeah.
Yeah. Okay.
So for those who are not involved in the inquiry in the future, it may be that Mr. Tucker's suggestion is a good one. There's not meant to be any surprise in my voice when I say that.
I'm going to treasure that moment. I've known Mr. Richards for 30 years, and that's the first time I've heard that.
Okay, thank you. I'll reflect on that, and if I think it's necessary, I'll ask for something to be provided, and obviously the condition would be amended accordingly. Then condition 4 has been deleted. This was referring to the 10-year splits, but the 106 covers the affordable housing provision. Just to double check, does it cover the 10-year split of affordable housing as well? Which is something I should have covered in the 106 session, but I assume it does.
It does indeed, sir. Yes.
Okay, thank you. So I assume both parties then happy with that coming out if it's already covered by the 106.
Yes, sir.
Yeah.
Yes,
Okay. Thank you. Then condition 5 refers to construction traffic management plan. I think this was previously 3 conditions merged into one. I did wonder whether or not the it should just be a construction management plan rather than a construction traffic management plan, particularly as it has bullet points that talk about a methodology in consultation with Network Rail and also the sort of hours of work. So for clarity, if it's referred to as a construction management plan in that first sentence, would that be clearer? Did the parties agree? Thumbs up from Mr. Richards. Anybody?
Makes sense from my perspective, sir.
Thank you, Mr.
Happy.
Okay. So yeah, so the word traffic then gets deleted from that first sentence. Sorry, the first reference to traffic gets deleted from that sentence. Okay, then I see condition 6 has been deleted as landscaping is covered as a reserved matter, but condition 7 remains. And I should say condition 6. I've raised it because obviously Network Rail had asked for them to be involved, but I see the comments about that they would be consulted on reserved matters applications. I assume council are happy with that. The external lighting, I did wonder whether that was also something that reserved matters could address, but I see that's still there. So just wondered why why that's still there, then Mr. Gould can explain first of all.
Thank you, sir. No strong opinion, if I'm honest. If that were wanted to be removed for later consideration of reserved matters, there'd be no objection to that. As you stated already, that was there at the request of Network Rail.
Okay. I noticed, Miss Medley, you've make reference to Baton Ecology. So is that why the condition is still?
It was, yes. I've just commented there, following your comments regarding Network Rail, really down to the discussions that you had, we had on Monday, and lighting in respect of the ecology. So it was just as to whether one was felt to be necessary in that regard rather than the Network Rail aspect.
I suppose, would external lighting be covered under landscaping, or is it something that falls outside a reserved matter and therefore needs to be attached to the outline permission? It's that sort of risk of it being one of those things that gets missed off, I guess.
We're happy with either.
Either way, yeah. The only thing I was going to suggest is what did it need to be a pre-commencement condition, or could it be prior to occupation or prior to first occupation? Any external lighting should be submitted to and approved in writing, and implemented or put in place, something along those lines.
Yeah,
it certainly could be, sir. Yes.
Okay. Mr. Thomas, you have your hand raised.
So I was just going to make a comment on that. The county doesn't represent Charnwood Borough Council on ecology matters, but I know where we've had this situation before. We've always been keen to agree construction lighting before commencement, in the interests of protecting wildlife species. So it's just a thought, really, that I know in the past we have asked for that as a pre-commencement condition.
Okay, I mean, this condition, I'm not sure if it's specifically targeted at construction lighting, or whether I read it as being the sort of the permanent lighting for the development, and I don't know whether the construction management plan would cover that, or potentially cover that aspect, or not.
We could include it in that, sir, if you.
In condition 5.
Yes, if you.
Yeah.
Yeah. If lighting needs to be managed as part of construction, then condition 5 is the obvious place for it.
Yeah. Okay. Thank you. Okay. So then also that then deals with condition 7. Doesn't have to necessarily be a pre-commencement condition. Then it can be triggered at a later point. Condition 8 deals with surface water matters. That's I have no issues with that condition. Then we have the Environment Agency condition, which I think is their wording sort of word for word. I think my question is whether or not 1 in 100 year was correct, or if I understood Mr. Holden correctly, that the scheme was looking to provide for 1 in 1,000 year. And I appreciate we may not have Mr. Holden here, so I don't know if that's something that can be clarified now or not. Anyone able to assist, Ms. Medley? Or
sorry, yes, I do have. So I do have a note from Mr. Holden. Bear with me. And he considers it the 1 in 100 to be acceptable rather than the 1 in 1,000.
Okay.
So if I may, I think he modelled for the 1 in 1,000, or the above 1 in 1,000, not that he thought that it was necessary to have that as the requirement. The requirement comes from the EA, which is the 1 in 100. That was a conversation that we had after day 1 of the inquiry to understand that differential, if that helps, sir.
Thank you. I think that may be where I'm getting the 1 in 1,000 year from. Then is from that modelling. I mean, obviously, yes, 1 in 1,000 year event is obviously worse than a 1 in 100 year event in crude terms, but I appreciate that's the Environment Agency's condition, and if Mr. Holden has said that that's acceptable, then okay, that's. I don't think anything more to say on that. I think there were some questions asked about whether or not all the works can take place within the site and be enforceable within the site. I think it's a third party has raised that issue, but I think we discussed that with Mr. Holden on Monday. So yeah. I'm satisfied with that. Anything else to say on that condition from anyone? If not, then we scroll through to condition 9, which is about foul sewage, and no comments on that, and obviously understand why that's recommencement. Similarly with condition 10 on tree works, again, that's all fine, and archaeology as well. Then we come to condition 12, which is about a suitable trespass-proof fence adjacent to the Network Rail boundary. And it says, in no part of the development hereby permitted shall be occupied until a suitable fence adjacent to the boundary has been provided and a management plan provided. I think the only thing I think this condition lacks is a sort of the need for that management plan to be agreed in writing by the council. So I think there's some wording that's needed there to sort of say that needs to be done before the fence is put in place. So maybe if I can leave that with the parties to come up with some wording.
Thank you. So yes, that's the verbatim condition from the Network Rail.
Yeah, I think it just needs that sort of, yeah, if the parties are happy with that. Then condition 13 deals with the access visibility displays for the access, refers to revision A, and the sort of dimensions are provided. So that's all okay. And similarly, condition 14 is dealing with the off-site work. So this is the traffic calming measures. Am I getting? No, it's the footway stuff. Footway measures. That's right. Sorry, because it's condition 16 that deals with the speed restriction measures. So condition 14 is dealing with the pavement works. Is that right? Everyone happy that I've got that right?
I believe so, sir.
Yeah,
I'm happy, certainly, sir.
Yeah, fine. Okay. Yes, it's condition 16 that deals with the speed restriction measures. Fine. And then condition 15, maybe where I made a mistake and confused travel packs with travel plans. And so I know that's being crossed out, but I think actually in reality it probably needs to be reinstated.
Absolutely, yes. I think your comments had related to the travel plan, travel pack. So we had that in before. Happy to reinstate that.
Yeah, I assume the council are happy with that as well.
Yes.
Yeah. Okay. Thank you. And then condition 17 refers to the landscape and biodiversity management strategy being submitted in accordance with general landscape matters and agreed in writing. When it says agreed landscape matters, does it mean the agreed landscape reserve matters? Presumably, is that what's meant by that condition? Otherwise, it's not clear what agreed landscape matters are.
That must be right, sir.
So it possibly just needs that to be added in. And I also wonder whether there needed to be a sort of timing clause that thereafter the works will be carried out in full. But does that need to sort of be said within an agreed timetable and retained thereafter? I think there's possibly a timing clause needed for when the works happen, and a retention clause as well.
Yes, sir.
So those could be added in. And then condition 18 deals with contaminated land, and I've got no comments on that. And then we have condition 19, a new condition that refers to noise mitigation measures, which is obviously something that I think Network Rail have raised, but also the noise and vibration assessment have also made recommendations. So that was missing. So I noticed the council and the parties rather have come up with a form of words. I suppose the only question is clarification on why it's pre-commencement. Is it because of needing to establish, or assess the final form of development? Is that the reason why it's pre-commencement, or could it be a later trigger, Mr. Gould?
It's your first point, I would suggest. There are a range of measures that sit within the noise and vibration assessment, and that some of that includes window details, for example, which would need to form part of the detailed submission on the outline. Sorry, on the reserved matters detail. So there's a mix of measures, and I think the reference to the summary and conclusions and the noise and vibration assessment, and for that reason, I think it would need to stay as it is my suggestion, sir.
Okay, thank you. Ms. Medley, any comments?
So no, I think my clients would be happy with that.
Okay.
Points understood.
Thank you. No, I think it's just double checking as to whether it was necessary, but I think it sounds like it is necessary as pre-commencement to make sure that the approved scheme is taken into account at an early stage. Okay, thank you. Any other conditions? I think that we've covered all the additional conditions I mentioned, but anything else from anyone else? Okay. Thank you. So that's been helpful. I think it might be useful to sort of see a sort of tidied up version of this schedule with any additional points that we've discussed sort of included, please. And then hopefully there won't be a need to discuss it again. But obviously, if there are any additional conditions that come up through the evidence of the witnesses, etc., then we can always discuss those if needed. But the party are happy to do that, and sort of similarly with, like with the 106, sort of provide an agreed final version for my attention.
Emphatically so, sir, yes.
Great, thank you. Okay, well, given that we've had quite a lot of time in terms of the duration of this inquiry, then I'm happy to sort of leave that until towards the end of the inquiry to sort of have that list provided. So certainly by sort of 27th, 28th of April, that sort of time frame.
I think my apprehension, sir, will be to try and get it done before we resume on the 4th, and hopefully Mr. Cook will make his appearance, if that's sensible. So we'll aim to have all that with you by then. And sir, in terms of the matter we left hanging over from this morning, obviously we're going to get the county council's revised figures and documentation tomorrow, so we were aiming to perhaps get a response to that by the beginning of next week, if that would be acceptable, sir.
This is on the school numbers.
Yes, sir.
Yeah. Yeah, that's fine. We didn't agree a deadline for that. So yes, on the basis that you get the figures by tomorrow, then yeah, something by the beginning of next week.
Thank you, sir.
Thank you. Okay, and I think probably Mr. Richards, in terms of the council's further information on the outdoor spaces and the allotments. Again, do we want to sort of set a deadline just to sort of focus?
Well, we'll be having a conference call about it as soon as this inquiry is adjourned today.
Okay.
But unless my team want to come up now and say, oh, they don't think that sort of work stream can be done reasonably quickly, I'd be wanting to offer, beginning of next week, just like learn from Mr. Tucker.
Okay. Well, I'm happy with that sort of time frame. If there's a problem, then I'm sure you'll let me know.
Yeah.
Thank you. Great. Thank you very much. So thank you again to everyone's contributions for that in that session. Is there anything else we want to cover before we adjourn for today? Anything else from you, Mr. Tucker?
Nothing else from me, sir. Again, safe to thank you for your forbearance given the indisposition of my witness, sir. So thank you, sir.
I think
it's disruptive to everybody, and I'm grateful the County Council have come forward as well, sir.
Yeah, no, I think it's yes, it's one of those things. But hopefully we've got a program now to get through everything in good time and reasonable time. So thank you, Mr. Richards. Anything from you? You're just on mute, I'm afraid.
I'm just checking the screen to my left. No, I don't think there's anything else.
So, so when we resume on Friday at 9:30, your witness, Mr. Higson, will be ready to give his evidence. Is that right?
Yes, and yes, that's right, sir. And I'll send you over a list of documents, and Mr. Tucker, obviously.
Yes, thank you. And Mr. Tucker wants to identify any documents he wishes to go to in cross-examination. Then, if I can have that as well, I think either by close of play tomorrow or certainly by 9 o'clock on Friday. To have that list, please.
Yeah, well, if I see my learner friends, then it will be any additional ones. I suspect we're probably looking at exactly the same documents.
Okay, thank you.
Thank you, sir.
Anything else from anybody else? Any queries or procedural points anybody else wants to raise? If not, thank you all for your contributions today, and we'll adjourn the inquiry and resume at 9:30 on Friday morning.
Thank you, sir.
Thank you all.
Sir.
Goodbye.
Sir.